Thank you all for your patience. Actually, the number of participants have gone above 100. YouTube for the participants. So we are sending the links, and that is why it's taking some time. So it will take another couple of minutes only. I request all you to please be here, and soon we will be starting our inaugural session.
Good morning, all. We are going to start the inaugural session of this workshop. And before that, I request everyone to please mute yourself and please keep your video in crop mode. So I request Dr. Arun to proceed, please.
Thank you, sir. Good morning, all. I am Dr. Arun Jyotinath, Assistant Professor in the Department of Ecology and Environmental Science, and I am the convener of the IPR cell Assam University. And the IPR cell is a recent development in the university, and as a first step to create awareness about this cell among the stakeholders, we are conducting this workshop with support from Estate Assam. So now, without going into details, may I now invite the chairperson of the IPR cell Assam University, Professor Piyush Pandey, for his introductory remarks and for the welcome speech. Sir, please.
So good morning, all of you. And in fact, it's my privilege of science and technology. I take this opportunity to welcome our, our Honorable Vice Chancellor, Professor Dilip Chandranath, who is also the chief patron of this workshop. Uh, Despite his busy schedule, because we know that he is very busy going on in each department due to the NAG visit, which is scheduled in the university. He is very busy, but he has given his time for this inaugural session. We are grateful to him. So I welcome our Honorable Vice Chancellor. I also welcome the team of Aztec, the nodal officer, the scientists, and everyone from the Aztec side for their collaboration and for their cooperation, because of which this workshop has become a reality today. I welcome all of you from the Aztec side. I also welcome all the experts who have given their consent to be part of this workshop and deliberate on the pertinent issues of IPR. And I'm pretty sure that these deliberations are going to be very useful for all the participants and it will meet their expectations. I will be short of my duties if I fail to welcome all the university members, especially the heads and deans who has cooperated so nicely in organizing this workshop. Whenever I was sending a mail, I was getting an immediate response from the heads and the deans. And thank you for your cooperation. And I welcome all the members from the Assam University family. And I thank you for your valuable presence in this inaugural session. I'm also thankful and I'm also grateful for the presence of Director IQAC, who has been taking keen interest in the activities of IPR cell since its inception, and she is present here today. So I welcome you, madam. I welcome Professor Sudipta Roy, advisor of IPR cell, and most important, I welcome all the participants, and I am glad to share this information that we got a very good response for this workshop in a very short duration. More than 250 participants, they registered, most of them from the university, and they have shown keen interest. We have kept a section of why you are interested in this workshop while filling up the Google forms from the side of the participants, and they have given wonderful answers, and we were very pleased to read those. So thank you, participants, for showing your interest, and that is why, due to the number of participants, we have shifted the attendance of the participants on the YouTube, and this workshop, all the deliberations and all the content of this workshop is being live streamed on YouTube simultaneously where the participants are attending. I also welcome the team which is with me right now, and because of their hard work only, this workshop is coming in this shape, especially Dr. Arun, who will be the host today and tomorrow, is the convener of the IPR cell, Dr. Amitabh Bhattacharya, Dr. Govind Sharma, who has given us the technical backup, because of which we were able to design this workshop on the online platform, and we could make adjustment between the YouTube and the Zoom platforms. Now, the importance of IPR for our university and in this region, and what role IPR cell is going to play. This is very significant because if we see the economic growth of a country and compare ourselves with other countries like China, there the application number of patent applications, and versus the number of GDP, the amount of GDP growth, it 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 matches exactly. We have, I'm sorry, my voice is echoing. So if we see the number of patents being filed within a country and its GDP growth, we will find that we fall short of China because of this, because they are filing more number of patents, and they are getting a good growth in GDP. So there is a really a connection between the economic growth and the number of patents filed from a country. And having such a rich uh, uh, intellectuals in this country, we have this opportunity in this region. Of course, we have this opportunity to put up the IPR into front line and take maximum benefit out of it. In fact, with this idea, this IPR has been initiated in this university, in Assam University, and as in the older denomination was that publish or perish. Now this has been going with the positive message and transforming into PPP, that is patent, publish, and prosper. So we have to go in this line: patent, publish, and prosper. And in this line, we have to make IPR activity more visible in Assam University campus. I'm again grateful to Aztec in cooperating with us and sharing our dream and motive in enhancing the IPR activity in the campus of Assam University and collaborating with us. So it's not like that IPR activities had not been going on in the Assam University campus. We do have 4 or 5 patent in very advanced stage right now. It is in the stage of almost award, where Professor Sudipta Roy and Professor Alan Sethi, they have submitted the patents, and there are 13 copyrights with Professor Supriyo Chakravarti. But we also, I need to add here 2 patent has been applied by Dr. Amitabh Bhattacharya from Department of Microbiology. Such activities are going on, but now we need to centralize these activities, and there is what IPR cell come into the picture to assist you and to make this activity more organized. So we come with the objective of IPR self has been identified as to create awareness about IPR among different stakeholders at Assam University, to provide protection, information, orientation, and facilities to the university researchers and scientists, to guide and advise researchers on how to obtain and sustain patent and intellectual property rights. In fact, we want to establish a linkage between national and state patent agencies, and we have taken initiative already. Aztec is with us, and one of the objectives is there, of course, to organize various IPR awareness programs in collaboration with national and state agency, and a string of that you see in form of present workshop, and also to work out modalities on behalf of university for commercialization of patent technologies that we see in the advanced stage. So these are some of the objectives which has been identified and which has been formalized by the IPR cell of Assam University. Once again, I welcome you all in this workshop, and I hope that the efforts which has been done by the IPR team in Assam University, along with in collaboration with Aztec, Guwahati, it will be very useful for all the participants. And with your cooperation, collaboration, we will see more IPR related activity in the campus, and we can show our intellectual strength in terms of patents, copyrights, and more such things. So once again, I welcome each and every present here in the workshop, and I'm grateful that you have joined in the inaugural session. So thank you very much. And now I request our Dr. Arun Jyotinath to please proceed further. Thank you.
Thank you, sir, and thank you for sharing a brief note on the objective of the workshop, and also sharing the potentiality of the Assam University that we have for the filing of the IPR in future. Thank you, sir. Now we'll proceed to listen the message from the Honorable Vice Chancellor, sir. And before we proceed, I would like to take the opportunity to share the brief profile of Professor Dilip Chandra Nath sir. So Professor Dilip Chandra Nath is the Vice Chancellor of Assam University since May 16, 2016. He was a professor of statistics in Guwahati University during December 1, 1998 to May 15, 2016. He was a former head, Department of Statistics and Director, Population Research Center, Guwahati University. Sir had been trained at different national and international universities, institutes like Guwahati University, Delhi University, Banaras Hindu University, Duke University, USA, University of Washington, Max Planck Institute for Demographic Research, Germany. He had started his teaching career as early as 1975. Sir's research accomplishment is truly amazing, and I am sharing some of this. Sir has successfully collaborated with more than 50 national and international scholars and contributed more than 200 research articles on various aspects of medical statistics, demography in reputed national and international journal. He was the chief editor for the journal Empirical Research in Social Science. He served as a chief editor of the journal Contributions to Applied and Mathematical Statistics, Demography in India. He is an active member for the 20 scientific professional bodies. He was a vice president of Indian Association for the Study of Population for a long period from 2006 to 2015 and an executive member of International Biometric Society. Sarah traveled several countries including USA, UK, Japan, Germany, France, Ireland, Vietnam, Thailand. So I have named some of these only for various academic purposes. He had been awarded prestigious Rockefeller Foundation postdoctoral fellowship to pursue his postdoctoral research in advanced demography at Duke University, USA during 1991 and 93. Sir also had received the Andrew W. Mellon postdoctoral fellowship for his assignment as visiting scientist there. Currently, he is also a member of governing body All India Institute of Medical Sciences, Guwahati. So this was only a brief coverage of a very vast profile that Sir has developed. So with this, may I now request the Chief Patron of the program and the Honorable Vice Chancellor, Sir, for his speech. Sir, please.
Namaskar. Good morning to everybody. I am very happy that Assam University IPR cell and the ASTEC jointly organized this workshop on IPR. Here present Professor Piyush Pandey, who is basically the chairman of IPR cell, and I hope that the nodal officer of the IPR cell in ASTEC is also present, and we have with us Director IQAC and many senior professors, other faculty members, students, and research scholars. So I welcome them to this IPR, workshop. Basically, formally it started just 1 year back, but before that, actually, we have a small unit in the SOT, School of Technology, under the guidance of Dean and Dean, Professor Supriya Roy. And that time, actually, they submitted few patents that got registered. And that is the beginning, possibly, the filing the patents in this university. And of course, the Supriya Chakraborty has done copyright registration. When we talk about the IPR, we understand the copyrights, patent, trademarks, trade secrets, trade dates, and so on. Now, basically, when in the university, we are mostly concerned with the copyrights and patent. You know, in our days, basically, in the northeastern region, even because I'm mostly beginning life here, even in the Delhi University and then in the BHU, we are not very much aware about that, the copyrights. My subjects may go for the copyrights, not many patents, and we are not even, after joining this university, I find that this awareness is very less among the faculty members regarding the copyrights and patents. So there is a need, there is urgency to aware the students who are the future of this country. They should know what is copyright, what is a patent, how to register it. And I can assure that university is supporting those registration fee. We have done it and we'll be doing it in future. And before publication, you can have the copyright or you can go for the patent. I think many of our faculty members, they could have done the patent registration. We may have 100 patents by this time, because the university of about say 30 years now, about 30 years, at least we should have had hundreds of patents, but we failed to do that. And now the scientists are coming, and they will be coming once this sensitization program is over, once the awareness program is over, and they will be learning it. So they will go for the patent registration. See, as a patent registration, the contribution of India is less than 1%. So, your innovative thinking should be, registered. People should know that your innovative thinking is a copyright or a patent. It is yours property. If you see, I think you have heard of Marconi. He got the Nobel Prize on what? In 1909, he got the Nobel Prize on wireless telegraph system, radio system. And do you know that it had been stolen from our very renowned Indian scientist, J.C. Bose? So it happened, and it is happening even now, even throughout the world. But so you should be cautious. Your ideas, your things should not be stolen or pirated. And that's if you are knowledgeable about IPR, this will protect you. And you can do more patent registration, more copyright registration, and take this India at a certain level. We cannot achieve that level if we cannot have patent registration, copyright. As Professor Pandey is rightly pointing out, the GDP is directly proportional to patent and copyright registration. So you are the people in the new education policy. Also, these are some stressing is there. Your work should be recognized, and that is the way you can do it. I hope this program, this sensitization program, this workshop will train up you, and you will not lose your idea to others. Let us make this program very successful one. And in this respect, I am very much thankful to STEC who are helping us, and they will be helping us and in future. So with this, I conclude. I think that this today's program with couple of hundreds of participants will make it very successful. Thank you all. Jai Hind. Arun Jyoti.
Sir, thank you. Sir, thank you very much for your very insightful comments and suggestion, and we believe that will help us to proceed further, and we'll try to involve more and more stakeholders of the university, and try to follow and try to collaborate with more other agencies, so that in future we are having more patents from the university. Thank you, sir, and thank you for your time, sir. So now we'll proceed to listen the speech from the most important architect of the program, because today we are here with the support of the agency, the hashtag, and the person behind this is no other than Srimati Bharti Sharania, who was very supportive from the very beginning of the program. And I am happy to share a brief profile of Madam here. So Madam is Nodal Officer at Patent Information Center, and she is also the head Science and Technology Division, Assam Science, Technology and Environment Council, Department of Science and Technology, Government of Assam. Madam did her post graduation from Guwahati University in Geography, and as the head, ma'am is looking after various ongoing schemes and projects of Science and Technology Division, both under DST, Government of Assam, as well as Government of India. Madam is also a senior scientific officer at Assam Remote Sensing and Application Center. Her field of expertise is geographic information system and remote sensing. Madam has more than 30 years of experience in the field, and this is definitely going to help us to achieve our objective also. So with this, may I request Madam to share a few words with us?
Namaskar. Good morning to all. Myself, Arun, Senior Scientific Officer and Head IC, Science and Technology Division, STEC, and as a Nodal Officer of PIC Assam. Most welcome all of you for the online workshop Intellectual Property Right. And thanks for inviting. I'm very happy and glad to take part in inaugural session of the workshop. IPR will be 8 to 9 April, organized by Assam University Chancellor in collaboration with STEC Guwahati. I think this is the first workshop regarding IPR organized by Assam University. Congratulations and all the best. The PIC is an intellectual property right facilitation center in public domains, and it functioning at state science and technology of different states in India. It extends support to inventors, innovators in registering the IP, and also creates awareness on IPR. In our state, Assam, the PIC is functioning at the office of STEC under Science and Technology Division, and it was set up in 2003 by the Patent Facilitating Center of Technology Information Forecasting and Assessment Council, Department of Science and Technology, Government of India and Government of Assam. PIC in Assam functions mainly to create awareness about IPR, especially patents in the state and neighboring region, and enable patent search in universities, industries, government departments, and research and development institutions of the state and around, to analyze the patent information on a regular basis and suggest new programs for research and development based on such information, and to guide the inventors in respect of patenting their invention. PIC also extend that function are to support people for servicing, securing protection for other IPs like trademark, design, copyright, geographical indication, etc. And also post-application matters. The PIC officials in our state deliver IPR talks, lectures at various programs for awareness of the masses. It is serving as resource body for the state, nation, as well as international seminars, workshops, research courses, etc. I hope in future also this type of workshop and seminar will be conducted by Assam University, Silchar, in collaboration with STEC, and for that, always welcome. I like to request all the participants be attentive, be free for interaction regarding IPR. Any hesitation, ask and be free. The importance of the objectives of the workshops are fellows who are expert and knowledgeable. They will elaborate in details of the theme. Thanks them also to help me to participate in this workshop. At the last, I like to request all of you, please take care regarding COVID-19. Health is wealth. Deha thaki lehe beha. All the best. Thank you to all.
Madam, thank you, and thank you first for your support, and secondly, ma'am, thank you for sharing your experience and expertise, and that will definitely help the IPR cell of Assam University in future. Thank you, madam. Now we'll proceed to listen the message from the director IQSC. So may I now request Professor Jayati Bhattacharya madam to share a few words with us. Ma'am, please.
Yeah. Honorable Vice Chancellor Sir, Professor Dilip Sinath, Chairman of the IPR cell, Professor Piyush Pandey, Advisor IPR cell, Professor Sudipta Roy, Convener Dr. Arun Jyotinath, Dr. Amitabh Bhattacharya, esteemed members of the STEC, esteemed very respected resource persons of today's program, and esteemed faculty members and other participants. Actually, the thing that because I have some experience of working in the IQAC, so I have some understanding of the emphasis of the components on where actually there is a lot of emphasis and which can actually really contribute to the enhancement of the standard of an university. And undoubtedly, IPR cell is one important among them. And IPR cell actually, it bears the testimony of the kind of activities, the kind of research that is going on in a university, and in larger context also, as Professor Piyush Pandey has said, in larger context also, the activities of the IPR cell has to do a lot with the development of a country, whether in national or international context. So, and I am very happy to see, because I tell you that is always, because I sincerely wish that this IPR cell of Assam University goes a long way and actually becomes a very, very important, a very strong component of the development of Assam University, because I always will have an emotional connect with this IPR cell, because I remember that is on 30th September last year I have assumed the responsibility of the director of the IQAC, and the first 3 note sheets that I have written, one was for the creation of this IPR cell, the second one was for the creation of the industry academia cell, and the third one for the tuition fee reimbursement of the students. So, and all 3 have become successful. So actually, and it is so nice to see that under the able leadership of Professor Piyush Pandey and the initiative of all other members, that in a very short time, this IPR cell has could make itself feel and could make some significant strides. And I do sincerely believe that due to this dedication of the members and due to the able leadership of Professor Piyush Pandey, this IPR cell of Assam University will go a long way to make a significant contribution, not only for the university, but for the larger society and the nation per se. Thank you so very much for giving me the opportunity to talk. Thank you.
Madam, thank you. Thank you for a very energetic speech. And ma'am, you being very energetic, this is a source of inspiration for us also to work more. And your constant encouragement has helped us immensely to
Thank you, Arun,
to build up for this workshop. Thank you, madam. We are going to end this inaugural program, and now I proceed for the vote of thanks here. So I, on behalf of Assam University and on behalf of IPR cell, would like to thank Honorable Vice Chancellor sir for his time and his encouragement, and for giving us the opportunity also to organize this workshop. So we thank Vice Chancellor sir. And then I would like to thank Nodal Officer ma'am for their support and also giving us the opportunity to collaborate with them and to work in future, so that in Assam University we also can have more and more like this patent filing and copyright from here also, and this will obviously improve the performance of the university. And I would also like to thank the IQAC director ma'am for her time and for her encouragement. And I would also like to thank the chairperson of the IPR cell and all the members who are associated with this program. I would also like to thank the head and deans of many of the departments who are attending this inaugural program. And I would also like to thank all the participants who are also attending this program. So with this, I conclude the inaugural session and directly move to the technical session that will start at 11:30. Or yeah, okay. So we'll not wait for the technical. We'll not wait up to 11:30. We'll start with the technical session just now. So thank you, everyone.
I think we have the experts for the first technical session with us. I can see Dr. Datta with us. So we can start, we can save time, because the good thing is that we are in time and we can have more interactive interaction and more deliberation in the technical session. So if we have some time and if the experts are ready, so we can proceed for the technical session.
Of course, we can proceed.
Okay, so that is wonderful. So I think Dr. Arun, we can go ahead. So we will directly proceed to the technical session first. And for all the participants are attending this workshop on YouTube platform, I request you to please be interactive. We have moderators. We have two very able moderators sitting with us on their laptop and noting your comments continuously. So at any point of time you want to interact or ask or raise any query, just use chat box in the YouTube link and put up your query there along with your name, and your question will be taken up. We will be selecting the relevant questions and we will be asking that with the speaker or the expert. So we will be doing that. So all the participants, I request you to please be interactive and please be vigilant on your YouTube link for this purpose. So now I request Dr. Arun to again please proceed. He is already doing a wonderful job. So I again request Dr. Arun to please proceed with the technical session one. Thank you.
Thank you, sir. So let us welcome Mr. Devashish Datta, Scientist B, Patent Information Center, Assam Science, Technology and Environmental Council, for his speech for the first technical session. So before we proceed, I would like to take the opportunity to give a brief introduction of Mr. Datta and would like to share with the participant here. So Mr. Datta is Scientist B of PIC, Patent Information Center, a state science technology program under the Department of Science and Technology, Government of India, which functions under Science and Technology Division of Assam Science and Technology and Environment Council. Mr. Datta has completed his MTech degree in Polymer Science and Technology from Tezpur University, Tezpur. Before doing his MTech, he completed his MSc degree in Chemistry from University of Burdwan. During his MTech, Mr. Datta obtained his formal education in intellectual property rights at postgraduate level from Tezpur University IPR cell. He is also trained at Rajiv Gandhi National Institute of Intellectual Property Management, Nagpur. His primary job responsibilities at the center include IPR consultations, patent searches, analysis of patentability, geographical indications, filing, and authorized users registration, awareness creation on IPR, motivation of young innovators, etc. As a part of PIC's objective, he has been actively participating as a resource person in various workshops, seminars, IP camps, etc., along with other science and technology related work of the council. So this was a very brief profile of Mr. Datta, and we are fortunate to have Mr. Datta in our workshop, the first workshop of the university. So let us welcome Mr. Datta and listen to him. Thank you.
Thank you. Please allow me to share my screen so that I can share my PPT with you.
Just a moment, sir. We're doing it. Just a moment. Sir, please see if you can share. Yeah, it's done. This is visible, sir.
Good morning, everyone. Respected coordinator and faculty members of the Assam University, dear research scholars and participants in this workshop. I hope I am audible to all of you, and my screen is also being visible to all of you. First of all, I would like to thank the organizers and the team of the newly formed IPR cell of Assam University for organizing this workshop in a short span of time. In these days, intellectual property rights or IPR has become a very well-known word. We often in our daily life get to hear these words. Intellectual property rights cut across all the fields, be it academics, literature, science and technology, research and development, business and commerce. It is everywhere. So it is very important for us to have the basic knowledge of IPR. So in this regard, the organization of this workshop can be considered very timely. Today we will discuss the basics of the intellectual property rights in details with you. So first of all, what do we understand by the word property? Property is a tangible or intangible entity which is owned by a person or jointly by a group of persons or a legal body. So where there is some law to define and enforce the rights, we can have the property rights. The bundle of rights of a person over an entity give him the ownership of the entity, and the control which is exercised by the person over the entity, it makes the entity a property of that particular person. With the property, there are many rights which are available, and they include the control of the use of the property, the right to transfer or sell the property, the right to any benefit from the property, and the right to exclude others from the property, etc. But for example, if we take the example of a plot of land, when we buy a plot of land, we have to prepare some documents like Zamabandi, land holding certificates, trace map, etc., etc. Only after that, we get the full ownership of that particular plot of land, and in that case, we get some control over that particular plot of land. For example, we can cultivate on that particular plot of land. We can build a house there. We can rent the property. So these are some rights that we get. And to get those rights, we have to work hard, and also there is effort necessary. So to create any kind of property, we need to have some efforts. Since the creations of our mind, like a book, a song, an invention, or a logo, or a symbol, designs, these are all involved with our ingenuity, creativeness, and also our intellectual effort. So they can be considered a kind of property. So this is known as intellectual property. So these properties, which are the product of our human brain, they may be as valuable as our plot of land or any other property. So there's a lot of importance involved in intellectual property. So we can say that the intellectual property means the creations of the human mind. Such creations can be an invention, maybe a design, or maybe symbols and names, and images which are used in commerce. At the same time, literary and artistic works. These are all creations of our human mind, and these are all intellectual property. So with this property, there are some rights associated. The legal protection for such kind of property, such creations, that is provided through a different form of property rights, and which is known as intellectual property rights, or shortly we call it as IPR. Those rights include our right to use the IP, the right to any benefit which is obtained from the IP, right to license it, right to transfer or sell it, and right to exclude others from the IP. So, intellectual property rights allow the owner to exercise his monopoly over the use of his IP for a specified period of time. So, these intellectual property rights take different forms. So, different kinds of intellectual property rights are available for different intellectual properties. Already, PC sir in his talk mentioned about patent, copyright, trademark. So, there are total 7 different forms of IP right. So, patent, copyright, trademark, industrial design, geographical indication, which is famously known as GI also, semiconductor integrated circuit layout design, plant variety protection, and farmers' rights. These are total 7 kinds of intellectual property rights. Today we will discuss in details these different forms of intellectual properties and what are the protection they provide. But before going into the details of each and every intellectual property rights, we need to know what is the need of the IP protection in our society. In our society, if we want to have some growth in the society, the protection of IP is very, very important. It is because if any new knowledge is created, if it is available freely to everyone, then the person who has created the particular knowledge, he will not get any incentive. He will not be no longer motivated to create any more new knowledge. So what will happen ultimately? It will ultimately lead to non-generation of any new knowledge. He will not be motivated to create some new knowledge. And as a result, our growth of the society will be hampered because no new technologies, no new art and culture, no new other design works, they will not happen because the person who has created such kind of new knowledge, he will not be motivated to provide any more new knowledge because everyone is allowed to freely copy his work, so he is not getting any incentive. So it is very important so that we develop a legal system where the people can share their knowledge and they get some return benefit. It will provide an incentive to create more new knowledge and to benefit the maximum. So the legal system which is already now available, that is the intellectual property rights. And it provides some kind of benefit to the creator so that he is motivated to create further. So in the cartoon below, the 3 scientists are talking to each other and they have shown their invention to the other persons, but they have found out that all their inventions are same, but nobody has already gone for the patent. So it is that they have put their effort, but it is already in vain. So it is very important that we protect our intellectual property. Intellectual property protection provides many benefits. It is actually the legal recognition and reward which one receives for his creative inputs. It leads to the social recognition and reputation. We all know how much appreciation we get when we get our patent registered. It also provides an exclusive right to monopoly over our IP and it can be used by others only with the consent from our side. So the owner gets a monopoly over his intellectual property. At the same time, promotion and protection of IP also encourages economic growth. Mr. Sir on his talk already talked about the growth and IPR relationship. In today's world, we have seen that many startups are growing, which are into the different fields, and they have many IP associated with their work. Some are holding some patents, some are working in the field of copyright, some have very beautiful designs. So if they can protect and accordingly maximize the benefit out of their intellectual property, then it will create a conducive atmosphere for the growth of the industries. It will create new employment. So it will ultimately bring prosperity to the society. And it is also important for enhancing the quality of our mind, because people will be motivated to create new creations, and hence the progress and our well-being of the society will further be enhanced. So these are some of the benefits of IP protection in short. So now we will go into the details of the different kinds of IPR one by one. First, we will start with patent. But before going into patent, we will discuss a few related terms. We often heard a few terms like invention, discovery, innovation. So before getting to know what is actually patent, we first discuss what these terms actually mean. So discovery, when we say the word discovery, it is actually the process of finding information, a place, or an object for the first time. We have all heard the very famous line, Columbus discovered America. So America was always available there. Columbus just introduced America to other parts of the world. So that is an example of discovery. But when we say invention, it is a product or process that provides a new way of doing something. Or it may be a new technical solution to a problem. In an invention, a huge amount of human ingenuity, creativity, and inventive is involved. If we take the example of Thomas Alva Edison, we all know how much he has worked hard to invent light bulb. So his ingenuity, creativity, and his hard work was involved in the invention of electric bulb. So it is therefore an invention, and it is solving the technical problem of removing darkness at night. So this is an example of invention. But these days we are also getting to know the word innovation frequently. So what does innovation mean? Innovation actually the translation of the invention into a marketable product or process. It may also be considered as a new way of thinking. So these are some creative ideas and means in an economic way. For example, there was a basic invention of MP3 player, but later on, Apple company, they have come forward with an innovation called an iPod. So it is a combination of aesthetics, some graceful ergonomics, and also the ease of use, for which it was commercially very successful. So this is an example of innovation. Now we are discussing about patent. The patent is an exclusive right which is granted by the government to the inventor for an invention, a product or process, or for a limited period. It gives the owner, the patentee, the exclusive right so that we can prevent others from making, using, copying, selling, or importing the patented product or process without our permission. It is the patentee only who can make, use, sell, or import his patented product or process, or he may license it to others. But to get these exclusive rights, the applicant is required to disclose the invention by providing a detailed, accurate, and complete patent description of the invention in the patent application. So when we file a patent in our patent application, we have to give the complete written description of the invention so that it is now available to the public. But that doesn't mean that your invention is going to be copied, because you are applying for a patent. A patent is a territorial right, and the patent obtained in one country is not enforceable in other country. It means that if we are applying for the patent in the country, in our country, India, then the rights of the patentee, it is limited to the geographical boundary of India. A person who is living in America or maybe in Britain, he is free to develop the same product in his country and sell it in the market, but he cannot export the patent to other countries, to specifically to India. So so the inventor, if the I think my connection is repeatedly being disconnected. I think it is okay now. So I am talking that if the inventor, if he wants to seek protection in other countries, he has to apply in that country for patent protection also. So that means a person who is having a patent in India, if he wants to have patent protection in America also, in that case, he has to apply in US Patent Office also. So the countries where we want to have patent protection, we have to apply in those countries. And if an inventor wants to apply patent in multiple countries, in that case, he can proceed through patent cooperation treaty, which is famously known as PCT also, PCT filing. So this is a treaty which is signed by almost 140 countries of the world, and through this we can apply in multiple countries for patent filing, which may be termed as international patent filing also. So it is less time consuming and also less costly. I have mentioned that the patent and any other IPR right is granted for a specific period of time. So the period of patent is nearly 20 years from the date of filing of the patent application. Why is it for 20 years? It is for 20 years because if patent is given for an unlimited period of time or for a very long duration of time, in that case, the progress of the society will be hampered because people will no longer need to generate new technologies, new ideas, and our progress will be stopped. But after 20 years, if it is made freely available and made available to the public, and if anybody can make the product or the process, in that case the product will be available at a lesser cost also, and at the same time the creator will be further motivated to create another creation to get patent and get commercial benefit. So what are the criteria for applying patent? Basically, there are three criteria, which are novelty, inventiveness, and industrial applicability. Novelty is that the invention must be one new one, and it is not published anywhere in the world in the past. And it should not be anticipated by prior knowledge in the public domain. Many of the times, many inventors actually, when we develop a new product, they go to they shoot a video and upload it in the YouTube. So this kind of things is like making your product freely available to the rest of the world, making it a prior knowledge yourself. So that kind of activity should be avoided. And for novelty to happen, the product should not be available or published anywhere in the past in the world. So that is the first criteria. Then so the second criteria is that the invention should have an inventive step. An inventive step, we can define it as a feature of the invention, which involves technical advance as compared to the existing models. Or maybe it is having economic significance, or both. And it makes the invention non-obvious to a person skilled in the art. So that means that the invention which contains an inventive step that is not easily obvious to a person who have a common knowledge in the particular field. So a good amount of human ingenuity, creativity, and our inventive thinking must be involved so that our work is non-obvious to a person skilled in the art. The third condition is that industrial applicability. The invention should be capable of being made or used in the industry. So these are the basic three criteria, but it doesn't mean that our invention should be very complex one, something huge, something larger than life. So it is not that. Something very small also can get patent. For example, I have given the example of safety pin. It is one of the most important, one of the very oldest patent. It was patented by Walter Hunt in 1849, and the patent number is US 6281. If you look at the safety pin, suppose we have a piece of wire or a piece of metal spring. Instead of having the safety pin, what will happen? If we use the wire to like tie our clothes, then the two pointed ends will pierce at the skin, and also there is possibility of accident. But in the safety pin, if you look at the pointed end that can be covered in the cap, and to pierce through the cloths, there is a pointed end, and to provide flexibility, there is a coil at the bottom part, which provides flexibility to the whole item. So even though it is a very small invention, it has given patent. And unfortunately, Walter Hunt, he transferred the patent to a company for just for a little amount of money. And the company who bought the patent, they actually they were able to generate a huge amount of commercial success from the safety pin. So we should be actually when we get a patent, we should also be very cautious towards the commercial effects also. So this is a small example of how we can get a patent, even though it is even if it is a small one. So what are not patentable? So well-established natural laws, the mere discovery of a scientific principle, the formulation of an abstract theory, the discovery of one living or non-living substance occurring in nature, these are not patentable. For example, a group of scientists visited the jungles of Amazon and they discovered a new species of frog, but they cannot patent it. because that particular living thing was already existing in the natural environment. They just found out, and they have actually informed the rest of the world that there is a new species of frog. The frog is available in the forest of Amazon. So that was a mere discovery. The inventions which may affect public order, good morals, or public health, these are also not patented. Method of agriculture or horticulture, these are also not patented. If we start patenting the method of agriculture or horticulture, how will the farmers will grow? Aesthetic reasons are also not patentable. And one important thing, mathematical or business method or computer program per se or algorithms, these are not patented. Computer program or softwares, these are protected under copyright. Even though computer program is not patentable in India, but these are patentable in US and many other countries. Again, traditional knowledge, which is already available in our society for hundreds of years, traditional knowledge as such is not patentable. So these are a few examples of non-patentable things. So what are the rights that the patentee gets? He gets the right to exploit the patent. That means he can get commercial benefit from the patent by licensing it to other persons to develop the product, or he may start his own company. So these are the commercial benefits. Again, he has the right to transfer the patent. He can provide the patent to someone else. He also has the power to assign the patent, or he can provide license or make a deal with a company. So these are also his rights. If somebody has infringed his patent, he has the right to sue him for the infringement. And also he has the right to sign the patent also. In academic institutions where we do a lot of research work, or in an institution, we must follow some precautious steps before applying for patent. First of all, the invention should never be disclosed to the public domain. I have mentioned about YouTube uploading, providing photos on the Facebook and social media. So these are some steps that can hamper our novelty. If it is disclosed, then the novelty will be lost. The results of our research and development that should not be published prior to patent filing in a journal. So many of the times we see that the research scholars actually directly go for patent research paper publication before filing patent. So that should be avoided because it actually leads to prior art. So first of all, we should provide importance to patent filing. Now I'm going to discuss the steps involved in getting the patent. First of all, we have to submit the patent application. There is a form, particular form. There is a method of writing the filling up the form, and we have to submit the form to the patent office. After that, the patent application is published in the patent journal. After that, examination of the application will happen. And if anyone has opposition to the patent, then he can oppose after publication of the patent in the patent journal. And hearing between the parties will happen. And if there is no objection found, then the patent will be granted and sealing will be happening. So these are basically the steps. So first of all, filing of a patent. So if an invention fulfills the three criteria of novelty, inventiveness, and industrial applicability, it is patentable. First of all, the specifications drafting is done. There are two types of patent application. One is provisional and one is complete. When our work is traced, the complete data is not ready. but there is business competition. In that case, a provisional patent file is done. The provisional application doesn't contain much data. It gives a brief sketch of the work, and there is no claim on what we have invented. So just a brief description is given. It is filed for book the priority date, the date of first filing. In India, the rule of first filing is available. So that means if two parties have invented the same thing, the person who has first filed the application, they will be given the priority date and they will be considered for a patent. So to avoid business competition, if the complete data is not available, in such cases, provisional patent filing is done. But if the complete specification, complete data is available, in that case, we can directly go for complete specification. The complete specification, patent specification contains the detailed data and at the same time also contains the claims, which is the main part of the patent application. If we have submitted patent, provisional patent application, in that case, we have to submit the complete specification within 12 months. So, after filing the provisional specification, we will have to submit the complete specification within 12 months. Otherwise, if the complete data is available, we can directly go for the complete specification filing. The fees for the physical filing is 1,750 rupees, which is given for demand draft. And for e-filing, the fees is 1,600 rupees. After the date of filing, after 18 months from the date of filing, the patent application is published in the patent journal. At that time, anyone can oppose the patent application if he has an objection to the application until the grant of the patent. After the publication, examination of the patent application will be done, and if there is no objection, the patent will be granted. And it is granted for a period of 20 years from the first date of filing, which is also known as priority date. In India, the patent actually takes a lot of time to get granted because our IP manpower is also very small. And at the same time, there is a huge load in the patent office. So it takes 2-3 years to get a patent. But after filing the patent, we will get a application number. We can mention the application number if we proceed for commercial activities, and in the bracket we can mention that the patent is pending. Here in the cartoon, two powers are discussing. One has invented on a brush which can be attached to his head, and he can apply to scratch his back. But he has informed his friend that the patent is still pending. So that is a joke. And now we come to infringement and remedies. The patentee has exclusive rights to prevent others from making, using, importing, copying, selling the patent without the consent. So, if a third party is violating these rights, it is known as infringement of patent. Such kind of infringement can be different types, which may be deliberate infringement, deliberate with minor modification to hide, indirect infringement, accidental infringement, or in some cases, there may be innocent infringement without any knowledge also. So, in such cases, the patentee can file a suit for patent infringement, and there are remedies available accordingly. The court can provide injunction, temporary or permanent, or in case of damages, an account of profit will also be provided. So these are the infringement and remedies. Now we are going to discuss about copyright. Copyrighted exclusive rights which are granted, and it is granted to the creators for their original artistic and literary works, including computer software. So in work, there are different kinds of work which are covered by copyright, which include literary, dramatic, and musical and artistic work. For example, novels, poems, screenplays, etc. Recitation, photographic work, choreographic work, music and graphical notations, and also cinematographic films, sound recordings, etc. So, copyright is a right to copy, distribute, and adapt the work. But it is not granted for mere ideas. The ideas must be expressed in a tangible form. So if you are having a story inside your mind, but you have not written it, then it is not copyrightable. You cannot copyright the idea. So the copyright, to get the copyright, you have to write the story and give it an expression of a story or maybe a novel. So in that way, it will be expressed in a tangible form. Then we can go for the filing of copyright for the book. For literary work, the period of protection is the lifetime of the author plus 60 years after his death. But in case of cinematic film, records, and photographs, the protection is for 60 years. In case of broadcasting, the protection is for 25 years. And after the expiry of protection period, the work enters into the public domain. So below you can see the picture of J.K. Rowling. We all know the story about her hardship in the initial days. But we know that in today, she is one of the richest women in Britain because she has earned a huge amount of commercial benefit from the copyright of her. So Harry Potter, which was one of the which was her creation, it was also adapted into various films. So from the main films also, she was getting the royalty. So in that way, because of the copyright, she has got a huge commercial success. So it is a very, we can say that this is a very bright example of how copyright can provide us security in regard to the protection of our IP and at the same time commercial benefits. Rights under copyright. So there are two rights. One is the economic right and the other is moral rights. So our economic rights related to copyright include the right to reproduction, translation right, right of public performance, right of broadcasting and communication to the public, rights of adaptation, right to interest in the resale in the works of art and manuscript, and also right to enforce protected rights. So from these rights, we can have economic benefits. But there is one another part of right associated with copyright, and that is moral rights. That is the right to claim authorship of the work. And at the same time, our right to object to certain modifications and other derogatory actions and to restrain in claim damages. An author who has the right copyright over his work, he also has the right to transfer his work to another's name, but his moral rights will always remain with him. That means if certain modifications and other changes are made to his work, which is harmful to his reputation, then he has the moral right to raise his objection. It is his moral right. To file a copyright application, there is a form which is known as Form 14. It includes the statement of particulars and statement of further particulars. And to register each work, we have to file separate application, and it has to be accompanied by the requisite fee. And the fee is for literary, dramatic, and musical and artistic work. It is 500 rupees per work. For literary and artistic work, which can be used and is capable of being used in relation to any goods, that is 2,000 rupees per work. And cinematographic film, that is 5,000 rupees per work. And sound recording is 2,000 rupees per work. So these are the different fees for different works. So just like patents, copyright are also territorial in nature. For example, if you are filing a copyright application in India, the rights of the author will be limited within the geographical boundary of the country, India. And if we want our right to be protected in other countries, we have to file separately in that country also. There are international treaties like Berne Convention for the Protection of Literary and Artistic Works, the Universal Copyright Convention, the TRIPS Agreement, which ensure the protection of copyrights of nationals of one country in other country. So these international treaties provide us the scope to file for international copyright application. If the term of the protection as per the country of the origin expires, in that case, the term for protection in other countries will also expire. So now the infringement remedies. Just like the patent, if someone is infringing the rights of the copyright holder, then the Copyright Act 1957, it has provided criminal, civil, and administrative remedies for such infringements. The owner can file for suit, injunction, claiming damages, claiming account of profit. So, such kind of criminal remedies include imprisonment for 6 months to 3 years, a fine of rupees 50,000 to 2 lakhs also. So these are the remedies that we get if our copyrighted work is infringed. Now we will discuss in details about trademark. It is actually a distinctive sign, and it provides identity to certain goods as those produced and provided by a specific person and enterprise. It may be a word or symbol or combination of both, numerals, shape, and packaging of food. In the pictures, we have seen all these symbols. For example, for the half-eaten apple, we can immediately recognize that it is the symbol of apple. The Coca-Cola bottle, we have always seen this. The Coca-Cola bottles are available in this shape only. Even the Coca-Cola word is written in italics in this shape, in this particular form. So these are all symbols and words and combination which are used as trademarks. You can see there is one R symbol, or in some cases there is a TA. The R means that the company has applied for the registration and the trademark is registered. And the TA means the company is claiming the trademark as their own, or they have applied for the registration of the trademark and waiting for the final registration. It is basically a marketing tool, and it builds the brand image and reputation. For creating the brand image, we actually use the trademark because it advertises the goods and services, and also it gives a promise to the customers about the uncensored quality. In case of trademark, the protection period is generally for 10 years, and we can renew it indefinitely for a period of 10 years, again and again. So what are the benefits of trademark? It is actually used by the traders, companies to distinguish their goods and services from their competitors. And when properly advertised, it is a very effective instrument to attract the consumers and to acquire their goodwill. With a particular trademark, a consumer can associate some level of quality, price, prestige. For example, when we buy a laptop, we have the symbol behind the laptop. It may be from HP, it may be from Dell, maybe from Apple, and from that symbol, another person can know the quality of the particular laptop because the symbol directly associates the goods with their origin. It also prevents other traders from deceiving the customers because the customers will not believe the goods and services actually produced by them were produced by the trademark holder. So false representation of the goods and services will also be prevented by the trademark. So this is details about the trademark in short. Now we will discuss geographical indication. It is famously known as GI also. It is also a indication. It may be a word, logo, or combination. It is a famous geographical area which is used on agricultural, leisure, or manufactured goods to identify them as originating from a particular geographical area. These goods, they have a special quality or characteristics or reputation which is based on the climatic and production characteristics of that particular geographical area. For example, the first registered GI of Assam, Muga Silk of Assam, that was registered by our Patent Information Center Estate in 2006. So it is also the first GI of northeastern part of our country also. So when we see the symbol of Muga Silk GI logo on the product, we get to know that this product is a pure product and also it is from the particular state called Assam. So it creates value and attract premium for the customers because it is a symbol of purity. Again, if we take the example of Darjeeling tea, we can see the Darjeeling tea GI symbol above the Lipton tea packet. So this symbol gives us the assurance that the packet contains only Darjeeling tea only, and there is no mixing in the packet. So only Darjeeling tea is available in the packet, and it is thus the assurance of purity. The important and special point about geographical indication is that it is the only IPR where the rights belong to the community, not an individual. Because most of the GI products are basically a traditional knowledge. So with the traditional knowledge, a whole lot of the whole community is associated. So for GI, the economic prosperity of the whole community can be brought. So GI is a very important tool to protect our traditional knowledge and at the same time bring economic prosperity to the community. So as I have mentioned that GI is available for national agriculture and manufactured products. These are some examples of some national products like Mysore sandalwood oil, Dholpur red stone. From the agricultural products, Orthodox tea of Assam has got the GI, the Naga chili, and also from manufactured products, Kalapuri sample, Muga silk of Assam. These are some examples of GI protectable products. So any product which has the quality, reputation, and characteristics which can be contributed to its geographical origin, they can be protected through GI. It will help the marketing prospect. As I have mentioned, the GI can bring economic prosperity to the community. It also provides legal protection to the GI products. Otherwise, the mischievous businessmen, they can misappropriate the benefits emanating from the goodwill and reputation associated with such GIs by misleading the consumers. It can also prevent unauthorized use of a registered GI by others. It is a symbol of purity, authenticity, and quality. Quality parameters are standardized and ensured, and it can give the surety about high value and high quality goods. And in this case, I would like to again mention that here the rights belong to the community, not to the individual. And they can enable seeking legal protection in other WTO member countries and thus boost export. Already, many GI tech products of Muga silk of Assam are being exported to various parts of the world, and they have got a very good response because of the GI logo. One of the very important part of intellectual property is industrial design. When we mention design, it is actually the aesthetic component. It is the external feature of shape, configuration, pattern, ornamentation, or composition of fine lines and color applied to any article, whether 3D or 2D or in both forms. It gives commercial value to a product and it increases its marketability. For example, the various colored mobile phones, the ornaments, jewelries. So these are some examples of designs. When an industrial design is protected, it ensures a fair return on investment. The protection is given for 15 years, and that is then 10 years initially, then it is extendable to 5 years, total 15 years. Industrial designs add to the commercial value of the product. When an industrial design is protected, it ensures fair return on investment. Because to create a beautiful industrial design, we have to invest a lot of time and effort. And for that time and effort, if the industrial design is protected, we can get a very good return on investment. So, industrial design also promotes the fair competition and honest practices. It encourages the creativity in the industrial and manufacturing sectors. And it also contributes to the expansion of commercial activities and the export of national products. So these are some benefits of design registration. Now we move to semiconductor integrated circuit layout design. The topography of an integrated circuit, it is a result of very huge investment, and a lot of time and effort is required to create the topography of an integrated circuit. And also at the same time, it has very substantial commercial value also. So in India, the topography of the industrial integrated circuits, they are protected through a different kind of intellectual property rights. This is known as Semiconductor Integrated Circuit Layout Design under Semiconductor Integrated Circuit Layout Design Act 2000. It is not protected under patent. So the electronic products which are which consist semiconductor integrated circuit boards, they can go for this integrated circuit layout design registration to protect their creation. It is given for 10 years, and the owner has the commercial right to has the exclusive right to commercially exploit his creation. If anybody, a third party, reproduce, import, sell, or distribute the IC layout without informing the owner, without taking his consent, then in that case it will lead to infringement. And just like other IPRs, reliefs are available under the Semiconductor Integrated Circuit Layout Design Act. The basic criteria for the registration is original distinctive distinguishing. The registration fee is ₹5,000. So basically, these are the IPR rights. I'm not going into the details of plant variety protection and farmers' rights because it is not directly related to the research and development activities. So now I will discuss that how IP can be a tool for economic development. As I have mentioned earlier, that the patent law, the rights given by the patent law, it gives the exclusive right to the patentee for which he can get a huge amount of commercial invention out of his commercial advantage out of his invention. We can go for technology transfer and investment, promotion of research and development. We can go for the development of new technology and commercial activities, revenue generation through licensing and assignment. So all these activities can be encouraged through patent registration. At the same time, trademark also influences the economic development from the identification of products and its origin, guarantee of the quality, advertisement of the product, increase in customer loyalty. So by licensing and assignment of the trademark also, we can generate revenue. Similar is the case with industrial design also. A person can get economic benefit by licensing of the industrial design also. And we have also discussed in details how copyright and geographical identification also can bring about commercial benefit. So we can be assured that intellectual property and intellectual property rights, when used judiciously, they can be a very handy tool for economic development. If we consider the importance of the intellectual property in the business, then we will find out that in our economy, in these days, the IP assets are very key business assets for the business organizations. When the business enterprises and other entire organizations are valued, the intellectual property rights held by the organizations also contribute substantially to the valuation of the particular enterprise. In many cases, when we see that one company is being taken over by another company, the company which is being taken over by the other, the IP assets of the particular company can also contribute to the value of that particular company, because they may have a patent or maybe a trademark which may have the value of hundreds of crores. So nowadays, intellectual property and intellectual property rights both are considered a very core component of the business strategy of a company. The business strategy is aligned very smoothly with the IP strategy. And from time to time, the companies carry out IP audit to identify their IP assets and compliance intent and also what is the need of their protection. Similarly, in the academic institutions also, the outcomes of the research and development activities in the academic institution, they can be filed for patent registration. In some cases, there may be industrial registration or copyright or maybe trademark also. The students can start a new startup. In that cases, they will need the help of trademark. So from a patent registration or maybe from a copyright, the academic institution can also tie up with industrial platforms to market and provide their product to the consumers. And from that, they can have a royalty by licensing their patented product. So for many institutions in India, the patents that they have registered, it has become a very good source of revenue generation for the academic institutions. And they have even many institutions have developed their strategy, their own formula to share the benefits also. So I hope some universities have started to explore the field of intellectual properties. In very near future, we will get to see that some university is also going to maximize their capability in technology transfer, patent licensing, and collaborating with industrial platforms to provide better products and research and development outcomes to the society. So again, now I would like to just remind you that the different forms of IPR and what it protects. So first of all, we discussed about patent. So patent actually provided protection to inventions. Copyright, it is the protection for expression of idea, like literary, artistic, and musical work. So if we say that a patent is for the science and technology field, then we can say that the copyright is for the arts field. Industrial design, it is for the protection of the external appearance or aesthetic component of the product. Trademark is the identification symbol or words or letters which associate the products and services of a particular company with the origin. Semiconductor integrated circuit layout design is for protection of the layout of integrated circuit or ICs. And GI protects the reputed natural, agriculture, and manufactured products from a specific geographical area. In many cases, we can see, we can have the example that in the same product, there may be many different kinds of IPR associated. For example, in this bottle, if we see the modern mechanism of the opening and closing of the bottle lid, in earlier cases, when we try to actually have a sip on the bottom, the lid will again come to its original position and it will hamper our drinking of the water. So later, the lock was developed in such a way that when we open the lid will remain its position until we forcefully close the bottle and the lid. So that locking mechanism, that is locking mechanism of the lid, that is a technical solution to the problem that we are having while drinking water from the bottle. So that is protected through patent. But the logo of the company, Flair, and also the name of the bottle, Gripwell, these are protected through trademark. And the aesthetic look of the bottle, the circular rings, the color combination, the shape, that is protected through copyright. So this is an example how different kinds of intellectual property rights can be associated with the same product. Same can be said for mobile phones also, where we can see that the same mobile can have hundreds of patents. The design of the mobile phone can have industrial design registration. The logo can have trademark registration. So in the same mobile phone, we are having 2-3 different types of intellectual property rights associated. So now I would like to show you, this is the World Intellectual Property Organization. It is an organization under United Nations. It looks after the IP activities in our world, and all the IP activities, the rules and regulations, these are mainly regulated by World Intellectual Property Organization, or shortly WIPO. If you get go to the WIPO website, you will get many freely available documents related to IPR, which are written in very simple language. You can study the documents, and you can yourself get to know many other important aspects of intellectual property rights. This is the IP India office. Our IP in our intellectual property domain, it is looked after the Office of the Controller General of Patents, Designs and Trademarks, CGPDTA. It's located in Mumbai, and it is under Department of Promotion of Industry and International Trade, Ministry of Commerce, and Ministry of Commerce and Industry. Our Patent Information Center, it is actually public facilitating center. It was actually a chain of PICs which is established in different states of the country by the Department of Science and Technology, Government of India. We provide support to the academicians, research scholars, scientists, grassroots level innovators in protecting their IPs. It is our job to create awareness to the field of IPR also. As a part of our objective, we have already established 5 IPR cells in the universities, other universities like Tezpur University, Guwahati University, Berlin University, Don Bosco University. So these cells are also functioning. Also, we are also providing support to other institutions of research like Indian Institute of Technology, Guwahati, IPR Guwahati. So we provide support in regard to all forms of IPR, starting from IPR consultation to IPR filing. In our next talk, my colleague Damani will discuss with you in details regarding how we provide support to the innovators, especially to the academicians and research scholars. Many research scholars and academicians from other education institutions are taking help from our center in filing their activities. During the last lockdown period last year, during that period also we got 2 patents registration for Guwahati University. So till now we have filed more than 80 patents. So we are looking forward that the IPR cell of Assam University will also actively engage in IPR related activities in the Barak Valley and also in the state. And we will collaborate with the university to provide support to the academicians and the research scholars of your institution. So this is our contact details. Our office is available at Beacon Bhavan, ABC, Guwahati. The email ID, you can always write to us in our email ID. My mobile phone number is also given below. So I hope during this talk we have now got to know about the basic details of the IPR. In the later technical sessions, our expert will discuss in details about the other aspects of intellectual property rights, and we are always here to help you. I hope if you have any questions, you will feel free to raise your questions. Thank you.
Mr. Datta, a grand congratulations to you for these excellent deliberations. Some part of your deliberations, especially the patentable, non-patentable right of the patentee and the GI tags, these components I liked and I found it very relevant, and I believe all the participants who attended your this deliberation might have the same impression. So thank you for your time, and now I am requesting Malavika Sinha and Jina Rajkumari. They are the research scholar from the Department of Microbiology. So they will take up the questions with you, the questions that the participants have. So they will put those questions with you. So, sir, please.
Okay.
And Malavika, Jina, please.
Good afternoon, sir.
Good afternoon.
Good afternoon, sir. It was a very nice presentation. There are many questions regarding this session, but we have selected 2 to 3 questions raised by the participants. The first question raised by S-Poll is that what type of creations are intellectual property?
Okay. So basically, all the creations of
What
human.
type of creations are intellectual property?
Okay. Can you hear me? Hello. Can you hear me?
Yes, sir.
Okay. So intellectual property or IP.
Yes, sir.
So all the creations of human mind that can be considered as intellectual property. For example, today I'm communicating with you using my desktop. I'm using my microphone. You are using your Wi-Fi technology. All these are creations of human mind because you have applied your brain how to create these things. So these creations all can be considered as intellectual property. So everything, let's say an invention, say a literary work, a musical work, some symbols. So all are creations of human mind and they are all intellectual property. I hope.
Yes, sir. Thank you, sir. And sir, questions raised by another participant to the money bug is that patent application where it is to be submitted.
Okay, patent application where it is to be submitted. So patent application, patent office, they have a regional office in Kolkata. Patent office Kolkata. So for our northeastern region, the application is filed in the patent office of Kolkata. And in our patent information center, we actually provide support to the innovators regarding filing their patent. So what we do that we provide, first of all, when we provide a form to the applicants, they can apply in which to us. Then we will give a search, patent search, and inform them whether their work is actually patentable or not, if there is any prior data is available. If it is found in our search that it is patentable, it is not already available, then we can proceed for filing of the patent, and the patent filing is done in Kolkata office. So for that purpose, after the application is prepared, after the complete or provisional specification is ready, it is sent to Kolkata office along with the requisite fee, or we can also go for online submission of the patent application also.
Thank you, sir.
Any more questions?
Yes. Sir, sir, I want to ask what should be the criteria for patenting my work?
I have mentioned in my slides that there are 3 criteria. First is the novelty, and that means your work must be a new one. It should not be already available in the public domain. Second is the inventive step or inventiveness. That means your work should contain some technical advance as compared to the existing knowledge, and we should make the work non-obvious to someone skilled in that particular field. And third is the industrial applicability. So these are the three criteria: novelty, industrial applicability, and inventiveness or non-obviousness. These three criteria are required for filing and patent.
Okay, sir. Thank you so much.
Okay, Mr. Datta, actually, congratulations to you for a very extensive deliberation. In fact, you have given a very detailed information. Most of the asking for your PowerPoint presentation, they want this file to be shared. Now, actually, we are live streaming this on the YouTube, and this presentation will automatically be there in the YouTube after this workshop. But still, they are interested in your presentation. So, will it be possible for you to share this presentation with the participants?
Of course, I will provide you the PDF file later through email. Which you can share with the participants. I will also share some other documents which you can share with the participants.
That is perfect. So thank you again. Thank you very much. So Dr. Arun, please. Thank you.
So, Mr. Datta, if you kindly permit, I have a one lemon type question. So if you kindly permit me to ask.
Yeah, sure.
I am interested to know the traditional food items being prepared by the ethnic groups or ethnic people, whether these are patentable. Not traditional food items or food products that are prepared by the ethnic communities, whether these are patentable.
Say any kind of traditional knowledge which is available in our society. So that is first considered under GI. So we have received many applications, 2-3 applications for some food products, especially prepared for pieces and other items from the communities of Assam. They have applied for GI registration. So accordingly, we have provided the support to them also. We have actually supported regarding this is the registration of successful registration of Pokasol, which is also known as Komal in Assam. Pokasol of Assam for GI registration, which is already been successfully GI registered. We are also working towards the GI registration of Assam tea also. So in case, so basically to answer your question, it is primarily considered under GI. But if there is any technical difficulty in the particular product, for example, it cannot be stored for a long period of time, or any other difficulty, like there is for example, there is some smell which is not liked by the consumers. So you have developed some technical steps to remove the smell, or you have developed some process to extend the period of availability or the period of storage of the particular product. So such kind of technical inputs, they can alone be considered for patenting. So it is not that everything which is traditional knowledge is not patentable. If you can provide some technical inputs which actually improves the product, those technical inputs, they can be considered for patentability.
Thank you, sir. Thank you for a very detailed response to my question. Thank you again, sir.
Welcome.
So now we'll proceed with the next speaker of the technical session 1. And so now we are having Ms. Damani Boisya, patent from Patent Information Center, ESTEC. So now we'll listen from this young and vibrant scientist from the ESTEC. And before we proceed, I would like to take the privilege to introduce the madam to the audience here. So Damani Boisya is one. She did her bachelor in engineering from Girijananda Institute of Management and Technology, Tezpur. She holds her bachelor degree from National Institute of Micro, Small and Medium Enterprises, Hyderabad. She has been working in Patent Information Center in various forms of intellectual property such as patent, trademark, copyright, design, registration, and then GI, etc. She has more than 4 years of experience in providing intellectual property support, starting from consultation, conducting searches for viability of registration of inventions, creations, etc., pre and post filing support. She also has delivered lectures, presentations on IP and various related topics in many platforms, both in in-house and invited expert. She has conducted over 50 patent searches, out of which many have been filed as complete as well as provisional applications at the patent office. Congratulations, madam. She has also she also has experience in providing post-filing support like first examination, report analysis, resolution, etc. of patent applications. She is well versed in GI registration with both pre as well as post-filing process that includes registration of authorized users of a GI as well. So congratulations, madam, for your this grand accomplishment, and we are happy to have you such expertise in our first IPR workshop. Thank you, madam. So we are waiting to listen from you.
Thank you for your kind words, sir. First of all, good afternoon to everybody. Hello. Yes. Can I know if I'm audible to everybody?
Yes, yes.
Yes, ma'am, you are audible.
Yeah. Okay. Thank you. So I would like to take this opportunity to congratulate Assam University for the setting up of the IP cell in Arun University, and also for this very good program, this workshop on intellectual property. I'm very glad that we both ASTEC and Assam University could collaborate on this program today. And I would also all of your time. And I would like to say that I want this program to be an interactive one. Rather than just presenting the information, I would like interaction from all the participants as well. If you have any questions, any queries regarding the content that I'm going to show, you can simply ask me. So now I would like to start my presentation. So I would like to share my screen now. I hope my screen is visible.
Only screen is visible, ma'am. Your presentation is not visible.
Okay.
YouTube में कितने हैं अभी? Ma'am, your presentation is not visible, and even we are not listening to you.
So thank you all for being with us today. And there is some technical issue right now. So Ms. Damani is trying to log in, and this thing happened actually in all the workshops and online conferences, we have seen such kind of issues, they emerge. So we are witnessing similar kind of problem right now. And Deepamani, Ms. Deepamani will be with us within 2 or 3 minutes. We have taken an alternative and that will work, of course. So meanwhile, I request you to be patient, to have patience. And for the participants, I am very delighted to inform that Dr. Rajshri Das Gupta, he is actually with us right now, and tomorrow it will be his day. He is another expert and he is a professional in the field of patenting, and he is a registered patent attorney. And tomorrow it will be his day, and tomorrow he will be presenting. Not only he will be presenting a very long lecture, but also he will be providing some training in the second half. So this is for the information for all the participants to be prepared for tomorrow. So we will be having a wonderful session from Dr. Das Gupta. And welcome, Dr. Das Gupta. I can see you that you are online and you are attending today's session also. So thank you very much for being here with us. And we are looking forward for tomorrow's session with you.
Thank you, Dr. Pandey. I'm not, it is really a pleasure to be introduced. I would like to see all of you coming back tomorrow as well.
Yeah.
And you took this opportunity to introduce me. That is really my pleasure and honor. Thank you for that. And just to mention, I'm not doctor. I'm just Mr. Dasgupta.
Okay. Okay.
I'm just a BTech and also I'm a LLB as well. I'm a registered patent lawyer.
Sorry, actually, this is
No problem.
in academics. This is the kind of habit we have. So
I understand.
I think you will pardon me. So
it's my
you're
responsibility to clarify, to have. I mean, I'm not so much.
it's okay. No,
not
it's okay. You have your credentials are unmatched, and you have great qualifications in the area of patenting and IPR. So I congratulate you for that, and thank you for being with us again. And meanwhile, we just wait for Ms. Deepamani to be back with us, and we are waiting for her deliberation. Thank you all. So Dr. Akil, are you with us right now? Okay.
Yeah, I am here.
Okay. Welcome to you, Dr. Akil, also. Okay, I think that Ms. Deepamani Bashe is presenting now. So let's proceed with that. Thank you.
Yeah. Hello.
Yes,
sorry,
madam.
Yes, I'm sorry for the inconvenience. There was a technical problem with my
It's okay,
device.
madam. Please proceed. Yeah.
So now I am actually. Is my screen visible right now?
Yes, madam.
Yes. Okay. Okay, then I'll start with my presentation then. Like it has already been mentioned in the previous. Okay, like I was saying, I would like this presentation to be an interactive one. Anybody have any questions, any queries, you can, without any hesitation, can ask me. Any doubt if you have. Okay, so my presentation, as the name of the presentation suggests, it's IP support by Patent Information Center, an overview. So the previous presentation was by my colleague, Mr. Debashish Datta. He has already given you an idea on how or why, what is IP, what are IP related rights, and why these are they are important. Now, now you are you have an idea of what IP is and a basic idea of all of that. So now next step is to if you want to get IP rights, how to proceed and whom you can go and contact. So the first solution that we have is the Patent Information Center. So and here I will discuss about how or what are the type of supports that we provide to the seekers, and what is the work flow of Patent Information Center, what kind of supports we provide. So yeah, before moving on to that particular main theme of my presentation, I would just like to remind you a few of the points that have already been, I think, discussed in the previous presentation. So yeah, why intellectual property, or maybe what is the importance of intellectual property and related rights? So the very first concept of intellectual property is that it protects your inventions, your ideas from getting copied, thus letting you reap full benefits from it. So the main concept is that you are getting an exclusive right over your invention or your creation, so that nobody else can copy it or get try to misuse it or get benefit which is not due to them. So there is more like an exclusive right you're getting for your creation, which also definitely will motivate you in future to go for more such creations and keep the flow coming in. Now, as already mentioned that there are various different type of IPs. There is patent, there is copyright, trademark, GI, many such type of IPs. So we are not only providing patent support to inventors or innovators, but we are also giving the artists, the creators, the full compensation for their creations. Like in case of copyright, in the previous presentation, it was mentioned about J.K. Rowling, her book that she wrote on Harry Potter. So that is a creation of an artist, and she has also got all the compensation and dues because she got a copyright for her creation. So intellectual property is open for everybody, every kind of innovation or any kind of creation, be it technical, non-technical, artistic, or anything. Everything can be protected under IP. All the people, all the form of IPs or kind of creations can be protected under intellectual property. Now, moving on to the next point is that many industries across the country rely on the proper enforcement of their IPs. By this I mean that there are many industries and many companies who are creating products. They are investing a lot of money and a lot of research work and resources on developing a product. And when they are putting that out in the market, if somebody comes and steals it, or to be very accurate, I would say, if copy it and sell it, so that would be a very huge loss for them, because they have invested a lot of time and resources on that. So for that, the main or the very good precaution that they can take is by taking IP on those products. And similarly, it is also useful for the consumers, because they are getting assurance of safe and guaranteed purchases from the companies. Now, it also contributes, as this point itself brings us to the next point, that is, it contributes enormously to the state as well as country's economy. Now, moving on to the main theme of my project, that is about the Patent Information Center. So what Patent Information Center is and what do we do? So first is that it is an intellectual property rights facilitating center in the public domain. It is there are very many PICs that are functioning at the state science and technology councils across India. So every state in our country has a state science and technology council, and most of them have a PIC functioning under them. So similarly, our Assam Science, Technology and Environment Council, which is the State Science and Technology Council of Assam, has PIC, Assam functioning under it, which was set up in the year 2003. Now, our objectives are to create awareness on IPR, to extend support to individual innovators, creators, universities, industries, government departments, and also research and development institutes in the state and around as well, to register their intellectual property. Now, as it is already been mentioned, that we have supported a lot of individual creators as well as universities and also many educational institutions, many very good and very nice kind of innovations, creations, and IPs have come up from all those applications. So next thing is we provide support in various forms of IPR, not even though the name is Patent Information Center, but we do provide support in different kind of other kinds of IPs as well. That is trademark, design registration, copyright, geographic indications, etc. Now, after like in my first slide, I mentioned this, that our one objective is to create awareness. So for that first point of creating awareness, we as the facilitating center, we organize various camps, workshops, and seminars all across the state for creating awareness and sensitizing people about intellectual property rights, their importance. This workshop being a similar kind of that venture. So now I have shared a few pictures just to give you an idea of what different kind of fields and different kind of platforms we have taken to create the awareness. So the first picture here is this is an IPR camp on GI, geographical indication. So PIC has registered Yuga Silk of Assam, the golden silk, as a GI in the year 2007. So after that, we have been taking all the steps in maintaining the GI, registering authorized users to that GI. So this first picture shows a camp that was organized at two blocks, Tingkong and Kwang in Dibrugarh, where we sensitized the local people, most of whom are wearers, weavers, and artisans of the Muga silk. So it was to sensitize those people, and I think we all will be glad to know that many applicants, many participants came to us for registering themselves as authorized user after this camp. So we can say that this camp was a success. Now on the right side, there is an image of another PIC official who was giving a lecture or taking class, I would say, at the Naipur, Guwahati. He was giving a lecture on IPR as a guest lecturer. So they have included this IPR as a subject as their semester course, and our PIC officials were invited as guest lecturers. They provided them the classes, they gave classes, and exams were also taken. So as per the syllabus and everything that goes. Now next is we have a photograph of another exhibition that was organized at Assam Textile Institute, Ambari. So this is again for Muga exhibition. I mean, this was more like a workshop, common exhibition where participants got a platform to interact with various experts that are there in the field of Muga. So all the artisans and weavers that are registered as authorized users, they got a platform to communicate and interact with experts that are working in that field. They are working in the field of Muga and doing research work. So they got a common platform to discuss about various issues related to the topic. And I think this proved to be a very successful one because again, we had many new applications from this one as well. So in this picture, we have our former director, Dr. Arun Mishra, who was addressing the participants. Now next, the second picture, it is from the Innovation Festival that is held every year in the Regional Science Center, Kanapara. This is a very good platform because participants from all over the state come here to participate, and our Patent Information Center also participated here, and we try to reach as much people as possible to make them aware about IP, to guide them. If anybody was there to ask for any help, we were there. So this is another platform where we have tried to create awareness and sensitize the people. Now, after the sensitization process, and let's next come to the part where we actually provide the support at our center. Now, this is a workflow chart this is more of a basic workflow chart of our center. It seems a bit complicated, so I will not go into details of this because it is comprising of all the different IPs that we provide support. So I have a simpler version of this. Okay. So this is a workflow of PIC. This is a simplified version of the previous one. So our workflow starts with the very first step is consultation. Then we go to application submission, or we receive applications. Then we go for searches, conduct searches on patentability and every other thing. Then we have filing. Then we also provide post filing, and finally that leads to grant of the IP. So the very first step, that is consultation, I would like to emphasize on this step because even though it's the very first and very initial step in the process, but still it's important because I have a case study, more of an example to share with you. So whenever somebody comes to us expecting guidance in intellectual property, or they asking for support in intellectual property, they already have an idea of what IP is, and they also understand that they need to have IP support or IP rights. So the initial sensitization part is already over. They already know that they need intellectual property and they want to get registered. Now the next thing is, which is important, is that they many times people don't understand, or they are not clear about which form of IP they should go for. So this I would like to make you understand with an example. So you can see there's an image of a bicycle on the screen. So this particular bicycle, this was designed by Mr. Saurav Jyoti from Bodhaghat. So he came to us and he said that he wanted a patent for this bicycle. So he said, I have created this bicycle, this is my creation, and I want a patent for this. Now, the first thing, I think it is already discussed in the previous presentation, that for patent, to get a patent, you have 3 criteria to fulfill. The first one, that it has to be novel, it has to be new, it cannot be existing anywhere in the world. Now, when we look at this bicycle, it looks like a very different one. It's not similar to the conventional bicycles that we see every day, but so it is already, so it somehow it clears the novelty part, because you might not find any bicycle looking like this anywhere else. But the next step, or the next criteria, that is called the inventive step, or the non-obviousness part. So if we go into the second part, we can see that even though this bicycle looks different, but the working of this bicycle is still the same. The conventional bicycles, what they use, the kind of the 2 wheels, there's a pedal there, there's a seat, and so the main working of this particular bicycle is same or similar to the conventional ones. That is, it is similar to the state of the art. Now, to actually give something a patent, you have to qualify that second part also, that it has to have a technical advantage over the prior art or the existing state of art. Now, this bicycle, even though it is looking different, but it does not qualify somehow the inventive step, because the technicalities or technical steps involved in this bicycle does not allow us to give the clearance to the inventiveness step. Now, and the third criteria is also somehow clear, because industrial applicability, it does have industrial applicability. It can be replicated and can be manufactured in the industries, and but this particular step of inventive step stops us from giving it an right for patent. Now, when he came to us, we told him that this is this process and this is the criteria and all. Now the thing is, we are here to support you. We cannot just simply say that you cannot get a patent and so it's over. So now the solution to this is, even though it is not qualifying for patent, there's another form of IP that can be used to protect this particular creation. So even though if we're not getting patent for this, we can looking at the aesthetics of this particular bicycle, the way the difference in the size of the wheels, the color, particular color that is used, the seat, the shade on the top. So all of these qualities or changes that they have made has led us to think, or maybe we can think of that this may qualify as a design registration. So that's what we suggested him, and he did accordingly. So even though it could not be patented due to the criteria, but it did. He did apply for a design registration, which was a more appropriate type of IP that by which he could protect his invention. So next he applied for the design registration, and we will be glad to know that his registration was successful. He received a registration. I have shared the certificate. So it was registered in 2020. So this example I shared with you is a very good example showing us the importance of the part of the consultation. The consultation that we do in our office is a very important step, because it leads to these kind of maybe discoveries, or where people might get disappointed as well, because if that person would have simply given an application for patent, his application might have got rejected because he doesn't qualify for the patent. But since we had a discussion with him proper, and we could come up with a solution and still protect his creation. So yeah, this is the first step of consultation. Now moving on to the next. So once the consultation is over, and we have decided which IP will be appropriate for the creation or the invention of the person, there's a form I have shared on screen. So this is a IP support form of PIC ESTEC. This is the very basic information regarding the applicant, what kind of support they are asking for. This is a form they fill up, and it, along with necessary supporting documents, whatever about the invention or the creation they have, their basic information on maybe their address or all other basic information, and along with the invention or the creation, they submit this to us, and after that we move on to the next step of processing it. So this is an IP support form which is common for all these kind of type of IPs. It is already mentioned: patent, geographical indications, copyright, design, and others. However, there is another form. This is for trademark support form. Now, in case of trademark, the kind of information or documents that we require are a bit different from those compared to the other IPs. So we have a different kind of form here. So this is for the trademark support form. Here again, the basic information are also about the mark that is there applying for registration. So after we take the application, next step is search. So like I said, getting a patent needs to be fulfilling 3 criteria. And similarly, also in trademark also, there are certain searches that are conducted. However, the other IPs like the design or maybe the copyright, we do not need to do such extensive or very or what I say, a very extensive or very elaborate search is not required. However, in case of patent and trademark, search is definitely required, because if we go for all the filing and then we go for drafting and everything and file it, and if it turns out not to be patentable, it's more like a wastage of the applicant also, and all the cost also, even if it's not much, but still it's more like waste of that. So particularly in case of patent and trademark, we go for searches. So in patent, I have already mentioned the criteria, that is novelty, non-obviousness, and industrial applicability. So once we receive a patent application, we conduct a search on the patentability of that invention. We have some dedicated softwares with us which we use for that search. And after that, according to the results that we found, we generate a report. We have a format for that as well, but I can share this with you now. So we generate a report in which every point is mentioned, why which are the points, maybe these criteria, which criteria they are fulfilling or where they are lacking, which are the, if it's not novel, then why, what are the similar or similar things available in the public domain. It can be in the form of product or in the form of a patent document itself, or maybe
Madam, we are unable to hear you or see your presentation. I think again there is some issue. Okay, yes.
okay, I'm audible, right?
Yes, you're audible.
Yeah,
Please go
yeah,
for full screen.
yeah, okay.
And there's some background noise also, madam, please.
Yeah. Okay, so getting on with where I was. Okay, so in case of patent, we conduct searches, where we see the whether these criteria are fulfilled by that invention or innovation. So the first step is novelty. One thing I would like to mention here is that when we do a patent search, it is actually on a global level. Even though patent is a territorial right, that is, if you are applying for a patent in India, your product will be protected only in India, not outside. But when we do the search is on a global level. That is, the particular invention or the particular work should not be available anywhere in the entire world. And that availability on the public domain should be in the, can be in any form. Either it can be in the form of a tangible, a product form, or there might be a patent application already filed by somebody else, or there might be an anticipation of that particular thing on a publication by some research scholar. So in any of these forms, if that thing is available in any of these forms in public platform, then that particular work loses its novelty. So yeah, this is a point I wanted to share. And the next point I've already mentioned, the non-obviousness. So non-obviousness actually is a subjective, even though a subjective matter, but there is a basic criteria that it is a measure of how far the particular invention is from the existing state of art. I mean, like for the example of I showed in the earlier slide, the bicycle. The conventional bicycles have the same two wheels and the pedals they use. The working mechanism is that same. Now, if somebody comes up with a bicycle which maybe has a different working mechanism of riding that particular technicality or technical point might get patented. But since in that case, it was the working was the same, so it did not qualify for the inventiveness step. But somebody if comes up with a bicycle with a different working process, maybe he is using steam power for or something else, some other form of energy where the person would not pedal or something like that. So that kind of a technical advantage or inventive step can qualify for the patentability. Now, the third criteria is industrial applicability. So industrial applicability again means that the particular product should be we should be able to replicate or produce that in an industrial scale, and it should have certain use as well. I mean, you cannot patent something which is does not have any utility, or does not have any purpose in general. So after all these criteria are fulfilled, once everything is these criteria are fulfilled, then we can move on to the next step of filing. Now, this is for the patent search. Now, we also conduct searches for trademarks. Now, for trademarks, the search is a little bit different, where we try to find whether a similar mark is known, or whether a similar kind of logo. Since trademarks, it is already mentioned in the earlier presentation that trademarks can be either a logo, it can be a word, which is called a word mark, or it can be a combination of both, which is called the device. So we try to do a search based on certain classes. Certain classifications have been set already, according to which different kind of services, products are fall under different kind of categories, and accordingly we conduct the searches to know if a certain particular mark is already existing in that particular class. By this I mean that there is a provision that if you are using a particular name for a particular kind of goods, like for example, I take my name, I am using my name as my trademark, and I am doing a business of maybe clothing, and I have registered my name as a trademark, and my class under which I have registered is clothing or fabrics and related. Now, if somebody else comes with the same name and they want to register their trademark in the same class, that is of fabric and clothing, they cannot do it because it's blocked by me. I have taken that class and it is under my domain now. But if that person is doing some other kind of business, maybe it's completely different from mine, maybe it's automobile or something like that, which is completely different, then they might qualify for the registration. So this is about the class that are present there for the classification. And there are certain marks which are already very known, well known to the people, so they don't actually go for the actual registration because they are very well known marks. So there's a list of actually very well known marks in the IP site of India. You can also go and look onto that. So for trademark, the searches are conducted based on this thing, whether similar looking mark or similar sounding, because phonetics is also important in case of trademark. Like for in case of Adidas, somebody comes up with a name called Adibas, which is already happening in all. So legally, you cannot use that term for that similar kind of product, because even though the word is different, but it sounds similar. Adidas and Adibas, they're phonetically similar. So that is also not registrable under the Trademark Act. So these are the two basic, like extensive search that we need to do. These are the two kind of IPs, patent and trademarks. So after this is cleared, we can now move on to the next step, that is filing. So again, for filing, for patent, there is a different system of filing, and for other IPs, there's a different, not a very huge difference is not there. There are just certain forms that are there provided by the authorities, and we have to fill up those forms along with the information of the creation or invention, and accordingly, along with the fees and other formalities, we can file the application. Now, here I have mentioned about patent because there is an optional, there is an option of provisional application in case of patent. So I'm saying optional because a provisional application is more of an application which you can use to secure the filing date. In India, we follow system of first to file. I mean, if we have filed a particular application on a certain date and somebody comes and files that same similar kind of work maybe later, the person who has filed first will get the advantage or will be treated superior to the other who has came later. So by provisional application, you don't need to provide all the details of your application, You just need to define the scope of your invention well, because you cannot go outside the scope after you have done that. And within 12 months of filing the provisional application, you have to file the complete specification, after which it can go in the conventional way of searching and other things. So provisional application is optional one. You can go for provisional if maybe you are at a state of your research where you have something in the materialistic form or something you can put on paper or about your work. Maybe it's not complete or it's not in its final state, but you have something to put on paper. So then you can use this information to file a provisional application, secure the date of your filing, and then you can take the 12 months later to finalize your work on it and make it, maybe improvise it or what other changes you need to make, and then file the complete specification within 12 months. So now this is in case of provisional application. However, if you don't want to file a provisional application, your work is already complete, and you can simply, it's already in its final state, you can simply and directly go for complete specification. And the complete specification includes the heart and soul of a patent application, that is the claims. So whenever you get a patent, the right that you get for a patent is it is restricted to the claims. Everything that you have input in the claims, you are only going to get the right for those things. You cannot go outside that domain. So a claim is the most important part in a particular in a patent application. And finally, the grant of patent is also given based on the complete specification. You cannot get a patent based on the provisional application. You have to file the complete, and after that, the processes of search and everything is done, and then you get.
Ma'am, your presentation is not visible.
Is it visible now? Hello?
Yes, madam, please proceed.
Can anybody tell me, could you all see the slide about filing the patent and other
Yes,
IPs?
yes.
Okay. Okay, so the filing process, once the filing process is done, we have applied for the patent and other IPs. The next is post-filing. So the patent or the other IP filing or registration process does not stop right at the application stage. So after filing, there are certain other kind of formalities and other things that are to be done for actually getting to the grant or final grant of the particular IP. In case of copyright and design, like others, they're mostly they are the registration is done, I think, without any such. There's no such formality, even if it's simpler comparatively. However, in case of patent and trademark, like I said, we conduct searches because of these formalities that are there. So in case of patent, there is a first examination report that is produced by the patent office. So after you have submitted your application, you have submitted your complete specification, everything is included, claims and all. So they again conduct a search based on that information that you have provided to them. And on basis of that, they will create a first examination report where they will mention everything, all the points where they might point out which of the criteria you are lacking in or which are already qualified. And similarly, if they have found some work that are similar to yours, they might also cite those documents or the patent documents or other things in that report. Now, our duty is to reply to those report or those queries. So for every patent application, there is a first examination report. There always be. You don't have to get demotivated that it has come up like that. So what you have to do is all the documents that they have cited, you can simply just go through them and try to point out the differences between those documents that they have or the work they have cited there. So when you go through them, you might find that the works or the documents that they have cited, they are not similar to what you have done. So that is a formality that is done to cancel out all those similar kind of works, so that when you reply to them, you can very clearly point out that my application or my work is different in these certain areas, and this is not similar to that you have cited. And once you have done that, you have resolved that FAR, you can reply to them as a reply to that FAR. So here in PIC, we help in that as well. So post-filing also, we provide support on that. So first examination report analysis, that is the documents that they had cited, then resolution of that. So the reply, how you should write the reply, how to convince them and to make them understand about the differences between the cited documents and your work. So all of that is taken care. So there is a discussion between the applicant and our officials, and then we finally do the resolution of that and reply to that. Now, in certain cases, what happens that maybe the first examination report resolution may lead to the grant. I mean, they might get convinced that yes, their work is different, but sometimes it do need a little bit of more elaboration or maybe a more discussion. So for that case, there might be a patent hearing. So the next step is patent hearing, where you have to go and maybe a one-on-one discussion with the examiner, where you can simply go to him and explain everything about your work, and whatever you have written on the FAR, the reply might not be sufficient. You can go yourself personally and explain about your work. So before, it used to be like you had to be physically present there in front of the examiner, but nowadays there is a provision for online hearing as well. And online hearing has recently been held in our patent office as well. So we guided the applicant for the hearing. And after that hearing, if the examiner is convinced, most of the time they are, and then finally it will lead to the grant of the IPR. So whichever form, it can be a patent, or in case of design or others, it can be granted within a very short span of time. But due to, in case of patent or trademark also, we have certain examination reports where again the same thing is applicable, where you have to reply to that. So after that, all these things are done, then you will finally get a grant for your IP. So after that, after getting the grant, there's another step that is involved in IPs, that is renewal of your IPs. Now, I think it has been mentioned that a patent has a lifetime of 20 years. You cannot get the right or exploit the right more than that. However, there is an option that if you don't want to renew the patent till 20 years, you can stop there. And maybe after 10 years, you don't go and renew your patent, and it will be open to all. So there is an option that if you want to renew it, you can keep it renewing it till 20 years, and if you don't want, then you can stop and make it open for all. So we also guide through that as well. So this is the complete process of getting an IP registration. It might sound a bit complicated, don't worry, but we are here to help you because everything is it becomes easier when we all come together and work towards it. So now this is the basic workflow of Patent Information Center that we follow here. So we provide you support right from the consultation till the filing, and also even after the filing also we are there to support you for all the units. Now next, after this, I would like to share some of the success stories, we can say, of PIC. So these are two of the granted patents that we have that have been registered recently. So the first one is from Professor Pradeep Fukan. He is from the Department of Chemistry at Guwahati University, and he got a patent for his invention, which is a copper catalyst for CN and CS bond forming reactions and process for this manufacture. So this is one application that I was saying that he also had a hearing. I think last year we had the hearing. So he came to our office, we had the hearing here, we guided him through the hearing, and after the hearing, after a few weeks of that, the patent was granted to him. So similarly, the second one is again from Guwahati University, so Department of Physics. It's a team of Dr. Bimal Kumar Sharma and group. So this is an improved AZO sputtering target for manufacturing transparent conducting film and metal. I think you can see in the picture that there is a circuit that is formed when it is completed by that transparent film. So you can see the LED light. That light is it is lit, so that shows that the circuit is complete. And this, they have got the patent for that film, the conducting film. It is actually conducting and conducts electricity. So for that they have got the patent. And I would also like to mention that this particular invention has been supported by ESTEC not only for getting IP support, but also in the initial stages. Like in ESTEC we have other form of projects as well, where we provide other form of guidance, other form of support like financial support as well. So we have a R&D, research and development scheme, where we provide financial support to research scholars, students, or other who have come up with such kind of invention or work. And so this project was supported by the research and development scheme of ESTEC. So this is more like a wholesome case, I would like to say, because it's a journey starting from the research work, going through it, then getting to the final result, then getting an IP as well. So this is a very successful case, I can say, for ESTEC. Now, trademarks. Like I said, we also provide support in other form of IP. So these are two of the registered trademarks. There are many others, but I just included this for my reference. So the first one is, it's a restaurant at Guwahati. So they have registered this logo. They're a very well-known name here. So they have registered their trademark. Now the second one, this is again a trademark of architectural form it is. So yeah, these were all supported by PIC. Next, again, the most important thing which we cannot miss is that the GI of Muga Silk of Assam. So Patent Information Center has registered the Muga Silk of Assam as a GI in the year 2007. So and since then we have been looking after the entire process. Like I said, after filing also there are certain other formalities like maintaining the particular IP. And in case of a GI, after you get registered, you get a GI registered, you have to keep maintaining it. Renewal has to be done. And also, in addition to that, there is a second part of the GI registration where we have to register authorized users. By that I mean that the people who are actually involved in the work related to the GI. In case of Muga Silk of Assam, like I mentioned in the earlier slides, that we had a camp. We organized a camp for the artisans and weavers who are involved in Muga Silk industry. So we identify those people and we register them under the authorized users of the GI. So Muga Silk is still going on, and the authorized user registration is still increasing. Recently, we have sent few more applications. So, and we have more than around 280 authorized users now under the Muga Silk of Assam, which is, we can say, among the highest of almost, among one of the highest of all the GIs that are registered in the country, in India right now. So it's a very high number. And the next one here is Boka Salt. This is the certificate I'm sharing with you. So this was again registered by Lotus Progressive Center, which is an NGO. However, all the guidance and support is provided by PIC right from the beginning, from application preparation and everything. So this is another success story. There are different other GIs that are on the pipeline that are being worked on right now. Yeah, so these are the GIs. Now, with this, I have almost come to the end of my presentation. This is the workflow of PIC, how we work, how we provide support to the innovators. And this is more like in message to all of you. We welcome you all. If you all have any, if you all want any kind of support in IP or related rights, you can come to us, you can contact us. So right now we have the present manpower that we have working in PIC are the Nodal officer, Srimati Bharati Saran. She has already addressed in the Nodal session. Then we have scientist C, Mr. Siddharth Devnath. Then we have scientist B, Mr. Devashish Datta, and project scientist myself, Deepam Vishwa. So yeah, you are all welcome for any kind of support you want from us. And with this, I would like to conclude my presentation. And I've also added this email ID of our center as well as a phone number. You can get it whenever you want any support. So yeah, I think it was a very bit of a roller coaster kind of thing. There was a lot of technical glitches happening. I hope it was helpful for all of you. You could get at least something from my presentation, I hope.
Yeah. This is fine, ma'am. This is fine. This is part of the online programs.
Yeah.
So, ma'am, thank you very much for your very elaborative, interesting, and very valuable deliberations. And I believe your contribution will enhance our understanding on the opportunities and challenges of the patent filing.
Yeah.
So, ma'am, there are few questions from the participant. So I request Malavika Sinha to share those questions with the ma'am. So Malavika, please.
Yes, Dr. Rajashri has asked who pays the fees for consultation and the professional activities performed by PPT for registering in IPR.
I'm sorry, I could not get it properly.
Pays the fee and the professional activities performed by PPT for registering any IPR.
I think the voice is not clear. There is some problem.
Okay, I'm repeating the question for you. If this is clear. So that the question is basically that who has to pay the fees? Suppose that PIC is processing an application of some IPR replication of an individual, then who is supposed to pay the fees for that? So that is how this is managed. So this is the question.
Yeah. So whenever going for a application for any kind of IP, the fees has to be paid by the applicant themselves. So if you're going for a patent application, so the patent application fees has to be borne by the applicant. If somebody is applying on as an institution or something, then maybe the institution will pay the fees. There are certain criteria which depend, because while you file the patent, the applicant legal, I mean on the document, whoever's name is written there has to pay the fees. However, I would like to mention that the service that we provide at our Patent Information Center is completely free. So all the support that we provide is completely free of cost. The only fees that you have to pay is when you apply the final application at the patent office or the other concerned offices, government departments. authorities. However, the PIC support is all free of cost. We don't charge anything presently.
Thank you. Actually, this last sentence was very important. Thank you.
Yeah, okay. Well, right now we don't have any registered patent agents.
Okay.
Yeah, that's so. However, since we don't actually, the reason being we don't have any registered patent is because the file application is filed by the applicant. So when you need to be a registered agent only when you're filing as the applicant. So if you are yourself the applicant, you don't need to be an agent if it's your work. So application is filed by the applicant themselves. They are mentioned as the applicant. So there's no need for any registered agent. Only if the agent is as an applicant in the application, then only there's a need for a registered agent. In our case, the applicant themselves is the authority.
Actually, there are some questions in the chat box of the Zoom itself.
Yeah, I can see them.
Just go through it.
Yeah, okay. I can see. How do you?
Well, the first question is answered actually, already answered.
Yeah. So registered patents. So how do you attend hearings? So hearings are basically the hearings are done by the applicant by themselves. We are not present in the hearing. We just support them, guide them through the process. But the hearing is done by the applicant themselves. They themselves go on in front of the camera and they interact with the examiner. And then after that, as per the hearing and everything, they get the patent or other rights. I would also like to say that we have almost like a 100% success rate in hearing because, as I mentioned, the hearings that we have conducted till now, all of them have got their registration. So we can say that we are successful in that particular area.
Ma'am, many thanks to you for attending all the questions, and thank you again, ma'am, on behalf of IPR University. And as per the schedule, we'll take a break now, and we'll resume our technical session sharp at 2 p.m. and then attend the lecture by a very young and hardworking scientist from Central University of Rajasthan, Dr. Akil Agarwal. So thank you all.
Before we break, I must submit my sincere thanks to both the speaker of this session. Actually, the first Mr. Datta has presented a very extensive lecture. In fact, right from the basics up to application, and Deepamani Madam has also presented how PIC can be useful in helping us for this IPR thing. So I'm so much grateful to both the speakers of this session, and thank you very much once again for being with us.
Yes, I would also like to offer my thanks from the entire PIC team. Thanks for having us today. Thank you.
We'll resume right at 2 p.m. Akil sir, good afternoon.
Good afternoon, sir. Good afternoon. कैसे हैं, sir?
It's nice to see you after a long time.
Same here, sir. How is everything going, sir?
Sir?
How is everything going, sir?
Yes, sir, it's fine. It's fine. But slowly the cases are also rising. COVID cases are also rising here in Assam also, sir.
Totally. Yeah. So this is again the same time of the last year.
Yes, sir.
Cases were much lower last year, and this time it has increased so much. So I don't know how far it will go this time. Yeah. This is a thing, sir. We have to deal with it.
Sir, your post-graduation classes are happening in offline mode, sir, or online?
Sir, up till third semester, we are having them in online, but for the fourth semester student, for their dissertation, we have called them in the university. So they are and they are doing their dissertation. We call them for like 1.5 months so that they can do something in dissertation and can go back.
Okay.
Yeah.
Here we are still on online mode, sir.
Yeah. And what about the doctoral student, PhD students?
Yeah, research scholars are coming, sir.
They are coming.
Yeah, this is open for teaching, non-teaching, and for research scholars. They have to attend physically, sir, and only for students, it's on online mode, sir.
All right. Okay.
So, sir, shall we start, sir?
I am okay, sir. Whenever you are.
Yeah. So let us wait for 2 more minutes, sir.
Sure, sir. Sure.
Yeah, 2 minutes.
Yeah. So only thing is, sir, like I have a next meeting at 3:10, but I am sure we'll finish before that. So there's no problem.
Okay, sir. Okay, sir. So I welcome you all again after this post-lunch session, and in this session we will listen to the lecture from Dr. Akil Agarwal from Central University of Rajasthan. So indeed we had the collaboration with Dr. Akil. We are working together on a research project of Department of Biotechnology, and this is a joint research, and we are trying to explore we are trying to develop some novel biochemical enhanced oil recovery technologies from the marginalized oil fields of India. So I am taking the opportunity to introduce Dr. Akil in this platform with the audience. So Dr. Akil is an assistant professor and a group leader of Energy and Environment Research Laboratory at Central University of Rajasthan. He received his PhD from Energy and Resources Institute, TERI, New Delhi, and Flemish Institute of Technological Research, Belgium, in petroleum microbiology. To further extend his perspective in the same field, after his PhD in 2009, he joined Petroleum Microbiology Research Group at University of Calgary, Canada, as postdoctoral scientist. Dr. Akil's areas of expertise are oil fields, soaring, and enhanced oil recovery. He had worked on several conventional oil and shale gas fields with several industries like Shell, BP, and then Chevron, ONGC, Oil India, Assam, Becker, Hugs, and many more are there. He has 30 publications in peer-reviewed journal and 1 US-Canada patent in his credit. Presently, he is a principal investigator of several projects funded by several government agencies, and including the prestigious Imprint 2, DBT Twinning, DST, SSTP, and industrial projects from Cairn India Limited, ONGC, Oil India. His current research focus on development of novel biochemical enhanced oil recovery technology for oil fields of India. Recently, he was invited in ISMOS 7 conference at Halifax, Canada to present about BCUR technology. He has won several awards and fellowships like Reliance Energy Innovation Award, JKLU Water and Environment Award, Best Business Plan Award, Sharp Travel Award, and many more. He is also a member of national and international scientific society like Association of Microbiologists of India and International Society of Chemists and Biologists. In addition to this, Dr. Akil has been invited as a resource person to a number of international conferences like ISMOS Canada, Reservoir Microbiology Forum UK, and University of Toronto, Canada. In 2020, he was also invited to give plenary lecture in 106th Indian Science Congress at Bengaluru. He had successfully guided 2 PhDs and 18 master students. So these are a brief coverage of his achievement. So we are very happy to have Dr. Akil with us this afternoon. So we are ready to listen from you, sir. Thank you, sir.
Thank you, sir. Thank you very much. And it's not a brief, it's rather very long and very humble introduction of mine. Thank you for this. And I guess I know Dr. Arun from last few years, and his credentials are again are very big, and he's so humble. So he invited me for this talk, and I'm really thankful for to your Vice Chancellor and the team for giving me this opportunity. And I hope I'll make the proper justification with the time which is given to me. So this is like a 1 hour which has been given to me. I have divided my talk in 2 parts. Initially, that why the innovation is important and why the IP in the innovation is important. And the second part is about the patents. But because probably the most of the second part has been covered already in the first 2 talks. So I will go very briefly about that. But first, let's start with why the IPs are important for the innovation. And as far as my credential and everything is there, I generally like to call myself as a learning facilitator, because I have been guiding number of biotechnology ignition grant projects as well as the startup projects, and we have almost written like 6 or 7 big grant projects for the different candidates, and out of that 3 got successful. So that is the thing, and this is all made me interested in the intellectual property, although that is not my area of expertise. But while writing the big grants and getting important innovations to fund by different angel investors, I started realizing the importance of intellectual property. So let's start my presentation. Is it visible? Arun sir, is it my slides are visible to everyone?
Sir, yes, sir, slides are visible, sir.
Okay, thank you, sir. So today's topic of my presentation is like intellectual property at early stage of innovation. In fact, I was making this presentation till the last half an hour, because I was thinking that what the early speakers have already given you the introduction. So I was omitting those parts and adding something new. So this was like, this presentation was actually completed just like 20 minutes before this talk. So probably there could be few mistakes while I will, because I haven't got any time for proofreading. So bear with me. And so let's talk about intellectual property at early stage of innovation. So, so before we get into the innovation, I'm going to show you these three pictures, and I hope you all can realize that these all three pictures are related to Assam. And one is, as you know, the first picture is of about the Johar rice, another is the Tezpur strawberries, lychees, and the third one is about the Muga silk. And you know, all these you three are the geographical indications which has been given to the Assam. Okay, and these geographical indication is one kind of IP, which actually is important for the kind of product which is made in particular geographical area. And one more thing to here to share is that all kinds of IP has directly or indirectly have some economic benefit. So that's why the IPs are becoming so important nowadays. And unless we cannot have we cannot have that idea of getting our IP until, especially in the academics, unless we are in our very comfortable zone. As a faculties of the in the higher education institute, we are very much interested in doing research, especially the faculties which are in of the science background. They are very much interested in doing the research, so they are very comfortable in their laboratories doing research, and they're telling their PhD student to do a lot more research in their particular area of particular area of expertise. But however, until getting a patent or getting an IP about one particular thing is altogether a different art. Okay, and we are very much comfortable in writing publications and getting more and more publications, and that's, of course, publications are important, but nowadays IPs are essential. Okay, so publishing is very good, and there was a saying that publish or perish, but now it is like either you get a IP patent or perish, or unless your institute does not get more and more IPs and does not generate the more and more funds for itself, probably it will become harder to sustain in the coming years. Okay, government is already trying to set up number of centers which can help these our academic institute to get more and more funding, and getting more and more IPs which can help you in getting more and more funding. And that's why the Indian government has taken a number of initiative, probably like even the Assam University must have this Institution Innovation Council. That is a scheme of MHRD and the Ministry of Education. They both together had formed the institutional innovation councils in number of university, and those innovation councils has a mandate of generating more and more IPs, generating more and more innovations in the universities. And one more thing which I want to tell you, that IPs and innovation cannot be separated. Okay, innovations are required for the IPs. Okay, and until unless we don't have an innovation aptitude, IPs cannot be generated. And in this way, government as well as our institute are focusing more and more on getting IPs. I am very much happy to know that the IPR cell has been set up in the Assam University, and I wish these people, all of this people who are related to IP cells of the Assam University should take more and more steps towards setting up an innovation council or the incubation center, or the more and more startups which can generate more and more IPs for the Assam University. So innovation comes when we leave our comfort zone, when the faculties or the student has to leave their comfort zone and go out and generate IPs. Okay, think about the products. Okay, so this is, in this way, we have come to a point in the present scenario where we have to blend our academic research with our business research, with a business proposal, and that is a key for innovation, right? Innovations is the only thing which can drive you for the IPs. So until unless the innovations are not taken seriously, probably generating IPs will be more and more difficult. So what does innovation means? Like whatever idea which is coming to the mind. Okay, there are thousands of ideas which comes to the mind of students when they are doing research with their supervisors. Sometimes they explain those ideas to the supervisors. Another time they always get fear that probably this idea doesn't make any sense to the supervisor, and they don't explain them. And that is a kind of, we need to give the student a kind of ecosystem where where their ideas can be, circulated and can be shared in a very free ecosystem, and then ideas which are making meaning. So the first key point is that idea should it should have a meaning. Money will come. So if we think about making money, probably the idea, we'll not get an idea which is meaningful. But if we have an idea which is meaningful, it will definitely going to make money. And then the idea should be like that, that it can take you to a next leap in the innovation. Okay, you can jump to the next curve, something like that. The idea should be in a is kind of a technology which can change the game, right? It should be a game changer technology in particular field, particular domain. Okay, and sometimes we actually miss some of those ideas because we think our student, or we think that unless I don't have a foolproof idea, probably I'll not be able to sell that idea. And that is again a mistake we do. And then our ideas, with the time, it gets expired, or it gets its natural death. So that's why we don't have to worry about that. We have to come to a foolproof product. Like if we think about the first iPhone, and now we think about the iPhone 11, there is a vast difference between the first iPhone and iPhone 11. Okay, if the Apple would have thought, no, I would have only launched the foolproof product, probably that iPhone have never come to our life. Okay, so that is a kind of improvement, this thing which we need to do. And then improve, of course. After getting the customer feedback, we have to improve, and then all of those things need to be done. And the one more thing which is more important is customize your pitch. Like whenever you are telling your idea to someone, you have to tell that why it is important and why you need to get the money for that idea, because for that innovation. So this is all innovation ecosystem which need to be developed in the institutes. And innovation ecosystem of a university can comprise of a technology business incubator, technology enabling platform, team building, mentoring, support for innovation, knowledge of IP, regulatory and businesses, translating ideas to enterprise, vision for scale up, networking and outreach. So you can see these are the very important and very peculiar thing which is required for a institute nowadays to have in their institute, in particular department, or as a IP cell. So all those IP cells which are forming in university should try to see that how whatever ideas are coming, whether these ideas are worth for getting a IP, and whether these ideas are getting further, that innovation should go for a business, right? So see, generating IP is one thing, but IP cannot be fruitful unless that IP is saleable. And that selling that IP is, you need a business enterprise, right? And or a startup in the institute. And that all can be done with the help of a technology business incubator, which can help you, which can guide you, which can do the hand-holding. A lot of hand-holding is required while generating these ideas. And that is why this is what is actually happening in our Indian institutes, that ideas are coming, and those ideas are really, really good. But they generally, before commercialization, these are the steps which need to be followed. And these steps cannot, because of the lack of mentoring and because of the lack of team building, those ideas get their natural death, and probably they will not be able to cross that barrier of technology level 3 to technology level 6, right? So like there are different technology readiness level which has been described which shows that how this basic research can convert into an applied research, and then what is the critical function, how the proof of concept can be generated. And each level has been given a TRL number. Like the TRL 3 is proof of concept which has been established, and then the TRL6 is prototype system verified. So this is where our ideas get lost in the academic institute, and this is what we have to change in the very coming time. This is what we need to change, that proof of concept should actually go these steps. So these are the steps which are actually known as valley of death. Okay, so your research resource is there, your idea is there, which is very good. However, the commercialization potential can only come when you can pass from TRL3 to TRL6, and this is known as like in our business terms, it is known as the valley of death. So we have to get a bridge. Okay, there should be a hand holding from the government, from the faculties of the universities for the students, so that they can actually bridge this gap and can set up, come with their own startup, or come with their own ideas which are worth commercializing, right? So for bridging this valley of debt, there are a number of schemes which has been started by a government of India. I'm not going to a detail of this schemes, because this is this workshop is on IP, and that's why I'll not explain them. But yeah, just for the idea that there are a number of schemes which government is giving number of fundings for this, for actually each step, each TRL to develop to a next TRL. There are a number of schemes which has been given, has been introduced by the government. Okay, like for ideation there are schemes, for the proof of concept there is a scheme, and one of them is scheme for the life science people is biotech ignition grant. Probably many of the faculties in Assam University know about this, or maybe some of those people also have these big grants. So BIG grant, biotechnology ignition grant. And once you have this biotechnology ignition grant and you have successfully completed it, probably you can go for a prototype. And there are a number of schemes like a NIDI and DST TBD schemes, nested scheme, TIDE, MEAT scheme. And then again, we have schemes for the commercialization, where the government will give you a funding for commercialization of your product, commercialization of your prototype, which is like SEBRI scheme, BIP and CRS, as well as there are a number of venture capitalists or the angel investors who are looking for the people who have set up their startups and trying to do this, getting their product commercialization. But in all of these schemes, growing from a ideation to the last step, one very important thing is that getting an IP. Because unless you don't generate a IP, you don't write a patent about your scheme, and you keep explaining it to number of people in the venture capitalist or to the angel investor, probably your idea will get, someone else can get patented that, or someone else can get another idea from your idea. So it is very, very important to patent your idea at a very early stage of innovation, and that is what I am trying to explain it here. Okay, this is about the big scheme which I am talking. I'll just give you a very brief introduction about this scheme, because this is a very good scheme for the students who have a very good concept or a research idea and they want a funding about it. The scheme is from the BIRAC, and this is a startup funding program of BIRAC, support research project that aim to establish valid proof of concept. So from ideation to the valid proof of concept, they are giving this money. And this money is a very good, a very handsome amount of money, which is like 50 lakhs for 18 months, exclusively for generating your proof of concept. Okay, a promising proof of concept. Okay, this scheme is open 2 times in a year, which is on 1st January and in 1st July. Okay, and nowadays, now I guess it's 18th big call is open right now, or maybe the last date is very near. So some of you want to apply, probably can target a next one. And who can apply? Any individual, student, academician, scientist, clinician, researchers can apply. The good thing with this is that even the students can apply it. You don't need to be affiliated to any institute for applying this. And that is our best part of this scheme. Okay, the areas of interest for this scheme is agriculture, drugs and vaccine, health device, bioenergy, industrial biotechnology, waste management, nutraceuticals, and data analytics. These are the areas where you can apply for this big grant. Okay, so now let's again talk about the intellectual properties versus the startup. So I have talked a lot about innovation, how the innovation need to be generated, but at what stage of innovation IP should be given, or IP should have been at least filed. Okay, so this is where when we before going out, before either the stage when you are writing it down, when you are writing your ideas, okay, and if you have something in hand in writing, or at a very early stage of prototype, your idea should have been has been filed, or your patent has need to be filed, because first of all, the important thing why filing a patent at a very early stage is important, because then you can show up your idea to number of thousands of people, and you can find the funders or co-founders or the funders who can fund your scheme. Similarly, the big grant, when you apply for a big grant, they actually prefer that if you have actually filed a provisional patent, that gives a validity to your idea, that if you have find a provisional patent, this means it is not just in your mind, it is actually written down on a paper which has been filed. So this gives an extra edge to your your idea, and that's why it is very important to file it in at a very early stage of the whole startup cycle. When you think about a startup cycle, okay, all these startups which has been nowadays successful, they have filed their IPs at a very early stage of innovation. Okay, and so first thing I told you, because once you have filed your patent, you can show it to number of people without any fear, because then your patent is there, and you have already filed a provisional patent, so no one else can copy your idea copy your idea, and you don't have that fear, and you can freely go to number of thousands of investors. And second is, getting a patent is a lengthy process. It takes time. It on an average it takes like 2.5 years to the 4 years, depending on the type of application which you have done. So until unless you don't find a patent at the right moment, it will be delayed in getting the final patent. Okay, your patent, when your patent is actually granted. So that's why it is again very important to get the patent at the right moment. Okay, to file a patent at the right moment. So then one more thing which I have actually explained is that government nowadays is encouraging more and more projects which could be entrepreneurial based project, which can have a best ideas and technology and solution at ideation stage, that are novel, market driven, and have a societal impact. Government is also funding the ideas which can generate IPs. Government is also funding the ideas which have environmental sustainability. But if you just write a basic exploratory research project, probably which does not have any commercial potential or novelty, are not going to fund. And this condition is going to be more and more hard. We'll see the more and more hardship in coming future, right? As we all know that the COVID times is going on, and lot of government funding for the science has gone towards the COVID. So rest of the amount of funding will only go to the projects which can actually give a valid product, a product to a market by which you can generate more and more, have a societal impact, or can generate more money or more economic benefit from that. So this is one more example which I tell you, that this is the company which we have just set up as a startup. One of our with some of our colleagues, which is Agarwal. So see, the startup certification we got later, but before that, what we did is we filed a patent. So although it is a provisional patent, as soon as our provisional patent was done, we have made this company as a startup company, and then just registered it for the startup thing. So this is what I'm telling you. You have to plan the things in a way that both the things can go simultaneously. You file your IP and then just set up your startup and go to the people who can give you funds about the setting up your startup. And probably there are a number of schemes even from the government which can help you in getting your IP successfully granted. One of them is for the Assam is STEC. I was listening to the presentations of both the speakers before me, and I found that the STEC is doing a very great job, while they are helping the academicians to file the patent, because as academicians we don't know, like we know our research, but we don't know which of our ideas is worth protecting, and that is a biggest lacuna. And that ESTEC is doing a great job in finding the people who can, who have the ideas which are worth protecting, and then giving them a giving them a hand holding for protecting their ideas. So this is really good. And there are a number of schemes from DSIR which can even give you the funding for filing your patent. Okay, so you can go to DSIR site and find about that there are schemes. I know these are like the competitive scheme. You give your idea, and the top few ideas will they will help you in writing the patents as well as filing that patent. Okay, so all the money for the filing will also be given by the DSIR. So this is about the IP thing. And before I move to the next session, probably if there is any question, I'm open for the question. Arun sir, or we'll do it in the last.
Arun sir is on break right now, and I'm here.
No problem, sir. Sorry.
Yeah, I think we can take the questions at the last.
Okay. So because this is a part which has been actually already done, but I guess there are some things which has been which were not explained during the first two presentations. So I will take these. Okay, so the first speaker has already told about the conditions of the patentability. Okay, so novelty, non-obviousness, and industrial application. I'll tell you one very like how basic and how simple an IP can be, how simple an idea can generate a IP. And this is a very good example of this. You can see a series of straws on this slide. Okay, and the first was a paper straw which got a patent in 1950. That paper straw is just for the patent. The patent was just for the paper straw which can help drinking drinking a liquid from a glass without spilling it, right? And then the second patent was given for the plastic straws. Third was about the flexible. There are nowadays the straws come which has a hinge neck. So that is a third patent which they got in 1964. And then there was another patent which was given to these crazy straws which have different, very crazy kind of designs. And these designs were used to attract the kids. And this was a utility actually, right? Because they were attracting the kids. And then there was another patent about it. And the last one, which was in 2009, I guess it was again a patent which was given to the flavored straw, which means they put a small, beads which has a different flavor. Okay, like different flavors of fruit or things. So the kids who were never used, like kids who are lazy in drinking water, they got a new toy by which they can actually drink water and can, as well as they have, because it is a flavored straw, so they can use this straw for drinking water. And this was again very useful because generally some of the kids do not have a good habit of drinking a lot of water, and water is very important. So this was again a very successful patent. So you can think about it, right? How a very simple idea can lead to a patent. And this is what we need to be open about it. That is the whole idea about my talk. If even one of you can get inspired by a talk and can think about an idea which could be very simple, very simple, but have an innovation, have an inventive step, probably that could be a idea worth patenting, right? So I'll tell you, like, as we say that under the blue sky everything is patentable. Yes, everything is patentable, but there are some things. Then we write about the exclude. Then we start excluding one by one the other things. So what cannot be patentable is the things which I'm going to tell right now, like the machines which is giving more than 100% performance, right? Because it is against the natural law. The machines, there is no machine which can give you a more than performance, more than 100%, right? It is against the natural law. So anything which is against the well-established natural law or the contrary to the well-established natural law is not patentable. So like if anything is against the Newton's law of gravitation, that is probably not patentable. Similarly, things the innovation or anything which is against, which causes serious prejudice to human, animal or plant life or health or environment. So anything you have developed which is against a public order or which is causing a serious prejudice to human, animal or plant life is not patentable. Like a machine, gambling machine, is it actually against the, against the humanity? So that's why it is not patentable. Or the device for housebreaking, if we have got an innovative house, this device for breaking the house and stealing the things, that is not patentable. Biological warfare material or devices are not patentable. Termination gene technology, I'm sure my friends from biotechnology understand this. Termination gene technology is not patentable. We all know about the BT cotton, and there was a termination technology involved in that. And then the embryonic stem cells, again, they are not patentable. And any invention related to the nuclear energy is not patentable. So anything mere discovery of a scientific principle or the formulation or of an abstract theory or discovery of any living thing or non-living substance occurring in nature is not patentable. So discoveries are basically not patentable. Anything which is actually present in the environment, in the nature, is not patentable. However, the inventions are only patentable. So anything already present in nature is not patentable, but the use of that thing which is present in nature to develop a new product and process, yes, patentable. Similarly, the mere discovery of a new form of known substance which does not result in enhancement or of a known efficacy of that substance, which means if suppose someone has patented one form of a product, and we just find a new form of that is not patentable until unless that the new form is increasing the efficacy of that substance. So for an example, there is a product and we make an isomer of that product, but if it is not increasing the efficacy, it is not patentable. So the mere discovery of a new property of a known substance is not patentable, or a mere use of known process, machine or apparatus, unless such known process result in a new product or employ at least one new reactant, it is not patentable. Means a new process, okay, is patentable. A known process is only patentable when it is resulting in a new product or employs at least one new reactant. So those are the things which are not patent. Again, what is not patentable? Mere just mixing two compounds together is not patentable. Like paracetamol is an antipyretic, while the brufen is analgesic, right? And you just mix them together in a drug. Okay, so both of these drugs will do their own work, and which has already been known to everyone. So that is not patentable. Okay, until unless they don't show any synergistic effect. You mix two compounds and those two compounds are doing their work separately is not patentable. But when we mix two compounds and the one compound is increasing the efficiency of the another one, or both of them has a synergistic effect on any other third property, then that is patentable. Then mere rearrangement of the things is not patentable. So for example, a bucket fitted with a torch. Torch will do its own work and the bucket will do its own work, right? So that is not patentable. An umbrella with fan is not patentable. See, all of these examples, these are not my example. I should tell you right now, this is actually given on the site of Indian Patent Office. All of these examples are given, all of these sentences are given. So these sentences are as it is taken from the site of this Ministry of Trade and Patent. And so all of this in their patent document, all of these documents are all of these examples and all of these sentences are given as such. I've just taken them from there and put it in my presentation. So there is nothing innovation in any of these slides which I'm telling you. I'm just telling you just for the information that at least we should have an idea that what is patentable and what is not patentable. A clock and radio in a single cabinet, a floor mill provided with sieving, all of these things are not patentable because both of the things which are present in them are independently, they're doing their own work. Again, this is very important, and this is like method of agriculture or horticulture. It is not patentable, right? Because India is an agriculture economy, right? And we, in our patent laws, we have clearly written that any method of agriculture or horticulture should be known to every farmer so that they can use it. Okay, and this way it is very clearly said that a method of agriculture and horticulture is not patentable in India. However, there are a number of countries which can do this. So these guidelines which I am telling you is about the Indian Patent Office, right? And this is not like this is not followed worldwide. These are for India. And method of agriculture and horticulture are actually patentable in other countries, but not in India. So like example, cultivation of algae, producing new form of known plant, preparation of an improved soil. All of these are not patentable because these are this is what our patent law says. However, our agriculture equipment is patentable. So if we develop any agriculture equipment which can help us in increasing the productivity or which is help us in harvesting the crop, those are patentable. So again, very clearly, a method of agriculture and horticulture not patentable. Any agriculture equipment is patentable. Plant and animal in whole or their part of other than microorganism are not patentable. For microorganism also there are some conditions, but microorganism can be patentable with some conditions, but plant and animal, no way, they cannot be patented. Clones and new varieties of the plants are not patentable. Similarly, a mathematical method or a business method or a algorithm, computer programs, those are not patentable because these are the outcome of mental process only and do not involve any industrial process or product, and that's why they are not patentable. However, we have a different IP for protecting the computer programs. Then anything which is literary, dramatic, musical, or artistic work, they are not patentable because they are protected and under the copyright. Right? So anything which is a literary work, dramatic work, musical, you have written a chapter in a book, you have written a publication, everything that is all copyrightable. That is not, that cannot be patented. Similarly, aesthetic creation, including cinematographic work or a television production, all of these are not patentable. Everything comes under the copyright. So presentation of the information in any method or method of expressing information, whether by spoken one, visual display, symbols, diagram, or information recorded on a carrier, all of these are not patentable. Next question was traditional knowledge. So traditional knowledge is not patentable. I heard that Dr. Arun has asked the question about the traditional knowledge, that the traditional food or the aesthetic foods which we have can be patentable. And the speaker has rightly said that these are generally the traditional knowledge is not patentable. We cannot patent the traditional knowledge, and this is already in the public domain. And we have a very famous case about the turmeric, right? The turmeric was there was a US patent over the turmeric, and then the CSIR and another NGO, two of them together fought a case against the US government to revoke that patent, to revoke that IP, and then it was revoked later, right? So traditional knowledge, and then the CSIR told that this is a traditional knowledge which is actually present in India from the number of years, right? It has been known in India for centuries. This is nothing new, so this cannot be given patent. And then the CSIR also did a very good thing, that they make a point that all the traditional knowledge which is present in our traditional literature like the Vedas and everything should be actually documented and should be available freely for everyone. So that process of documentation is actually going on. all of that, those things are made digitally and then should be available, probably will be available for everyone to see. So everyone can use them, but no one can patent them, right? Everyone around the world can use those traditional knowledge to make any compound, but that should not be patentable. Okay. Yeah, so this is what I would like to explain for this my presentation today. I guess I have finished quite early, within 45 minutes. So sir, now I can take questions if there are a few questions about setting up the startups or anything about patent. I'm ready to take the questions.
Yeah, thank you. I have always appreciated your skills to give such wonderful lectures. In fact, Dr. Akil Agarwal, I'm a big fan of your speeches and presentations. And today also you have delivered such a wonderful presentation. And I need to mention here, because you are getting very good response in YouTube, in the comments. The participants, they are giving very good feedback for your presentation. So I need to share that. I must, this is my responsibility basically to tell you this.
Yes,
and thank you for this. So in fact, there are only couple of questions there.
Yes, sir. Please tell.
Yeah, I'm just requesting my moderators to get me the questions.
Yes, sir.
Just pass it on here. Okay. This is Ms. Chakrabarti is asking, are there ways of patenting natural compounds which are bioactive?
Ma'am, I just told you that natural compound, if it is present in the nature, that those things cannot be patented, right? Any compound which is already present in the nature cannot be patented. However, if there is a compound bioactive, if a compound which is present in nature and you have done any modification in that, okay, and that could be patentable, or if you have made that it bioactive by doing some chemistry changes or by adding some chemistry to it, it can be patented. So again, here I want to add one more thing. Although there are a number of experts, and probably I am not an expert of patent, so what I am saying is need to be, if I'm wrong, please forgive me. But what I'm saying, what I want to say here is, ma'am, things can be patented. Only thing is you have to discuss it with the team and ask them how to go about a patent for that. So natural compound as such in our laws, what is written is natural compound which is present in nature cannot be patented. But I am sure if you have made it bioactive by doing some chemistry and changing some chemistry to it or adding some functional group to it, it can be patented. It is just a matter of how to write the claims.
Okay. I think this had been answered. Yes. So this is a wonderful answer. Then there's another query, and I think this question comes quite frequently when we talk about IPR issues, that what should be the criteria for patenting your work? Should I publish my work before applying for a patent? So publication versus patent.
Very good question. So there are two things here, right? So what I'll say is, first you file a provisional patent and then go for publication. But if there is a condition that you need because our universities has always have guidelines that you can do your PhD unless you don't publish two publication or one publication. There are I'm sure Pandey sir will agree with me that there are always conditions that you have to have two publication or one publication for submitting your thesis. So in that condition, remember that after your publication is published, you still have 6 months to file the patent. This is a very new, thing which has been added to the patent laws. Yeah, after the publication also you have 6 months to file your patent, but not later than 6 months. Or maybe time limit is some different, maybe 6 months or 8 months. But again, I will recommend you first do the provisional patent. Provisional patent does not take a lot of effort because you don't have to write the claims, okay? But in that way, what you have done is you have filed a patent. You have got your priority date. Your patent will be whenever your patent will be granted. Your priority date will be is already fixed. So file your provisional patent. Go for publication.
Again, a wonderful answer, and probably this is the correct way to respond this. And thank you for this. So, no more questions. Other questions, I think this has been addressed through your presentation. So, thank you very much, Dr. Akil. And I want to put one thing in the discussion, that in the morning session we had the experts which were telling us that how what is the process of patenting and how the patenting is done, how the IPR issues, what are the different IPR issues, and we should know before going for patenting. But there we invited Dr. Akil Agarwal with a different perspective, because the perspective of an innovator should also come into the picture, that how we should look, or why when we should start thinking about to go for patenting or to go for IPR. The perspective of a person who is a stakeholder as well as who is going to be a patentee. So that has to be, this perspective has to be there. And I'm so much grateful to Dr. Akil Agarwal for providing this wonderful deliberation and bringing this perspective very clearly, in a crystal clear manner. He have presented the things in a wonderful presentation. So we all, on behalf of the IPR cell of Assam University, I am thankful to you, and pretty sure that many of my scientist friends which are there in the participants, they are attending this workshop, they are going to be very much benefited with you, and they will be in contact with you if they have any more queries. So with this, I thank you again, Dr. Agarwal, for being with us. And friends, with this, we come to the end of today's technical session. So thank you all for being here today. And tomorrow we will be having another very energetic and very we are looking forward for a wonderful session tomorrow. Again, we have Mr. Das Gupta tomorrow. So he was attending today's program also, and Mr. Rajarshi Das Gupta, he will be having 2 sessions tomorrow. So looking forward for those 2 sessions. So for today, I just thank again to all the panelists and to all the participants. And for today, I think we can close the session. So thank you all. Thank you for being here. Thank you very much.
Thank you, sir.